It. Okay. Good morning, one and all. My name's Andre Ruth Gunderson. I will be your judge today for your probable cause hearing. We're here for three purposes. That is to determine, one, whether the police had probable cause to arrest. The second is to determine whether you should have an attorney appointed to represent you, and if you can afford an attorney, I'll be able to appoint the public defender's office. If you have a private attorney, please let this court know so that we can try and reach your attorney to let them know you're before the court today. And thirdly, the purpose is to determine what type of pretrial release or bond, if any, is appropriate. This is not your trial. You have the right to remain silent. Anything you say can and will be used against you, and we are being recorded. So I strongly recommend do not state the facts of your case to me. I am not your trial judge. This is not the appropriate place. When arguing that, trying to give me the facts, you may admit things that will be then used in subsequent hearings. So please just refrain from that, and we will proceed now. I know we have a few private attorneys here. So first of all, public defender, could you please place your names on the record, your presence?
Morning, Your Honor. Jared Hopper, appearing Assistant Public Defender.
Good morning, Judge Christina Gomez on behalf of the state.
And Danielle X on behalf of the state.
Okay, all right, so, before we get to the main jail, Mr. Dessler, I have a couple of attorneys that have been waiting all morning here as well. Okay, thank you. All right, let's see, we have Tara Giaffione.
Good morning, Your Honor.
I think, is she at the main, or is she?
She's present, Your Honor. She's approaching.
Okay. Let me just get your client up. Okay, there she is. All right. And, sir, your name?
Good morning, Your Honor. Jeff Brown on behalf of Ms. Giaffione.
Okay, Mr. Brown. All right. Miss Giaffione, you are charged with DUI with damage to property, count 1, and count 2 DUI with damage to property or person. Also count 3 DUI alcohol or drugs, first offense. Count 4 failure to stop, remain at the scene of the accident involving, I guess
Non-serious injury.
Non-serious injury. Okay, they have served there like in B.
I understand.
I get it.
And Judge, she has already bonded out on counts 1, 2, and 3. I think we're just here to discuss count 4, which is a third-degree felony. She's being held for magistrates.
That's correct, Your Honor.
She's here for all six.
For PC purposes. I apologize.
We did not address it because she did not have her attorney present, so I don't know. Yes, right. All right, so, but we are gonna be addressing all 6, okay, so if I can finish?
I'm sorry, Judge.
That's okay. All right, 5, license not carried or exhibited, and 6, failure to use due care. I have reviewed the probable cause affidavit, and I have found probable cause. Counselor?
Yes, Your Honor. She has posted a $2,500 bond. We asked the court to release her on her own recognizance on the remaining charge, which is failure to remain at the scene. She was found very near the scene. She has been a resident of the county and/or Palm Beach all of her life. I've known the family since before her birth. I've known her parents for decades. They've always lived in Broward and Palm Beach. She has no prior record. She's posted a $2,500 bond, and I'd ask the court to release her on her own recognizance on the remaining charge, which is failure to remain. The bondsman is present, and he's outside the courtroom, and we'd ask the court for her to be released on her own recognizance on the remaining charge, and to keep in place the convenience bonds that have been set on the prior charges and have already been posted.
State?
Judge, we would be asking for a bond to be set on charge number 4, the failure to stop or remain at an accident involving non-serious injury. As defense counsel said, she's already posted the convenience bonds in the amount of $2,500 on counts 1, 2, and 3. Those are misdemeanors. This is a third-degree felony. So since you've read the allegations in the report, she did cause this car to spin, she did drive off, there were injuries in which people had to go to the hospital for. We would be asking for a $1,000 bond, which is the standard bond on a third-degree felony.
Okay. I am going to order a $1,000 bond on count 4, and also no alcohol. One of her requirements for her if she bonds out is no alcohol.
Thank you, Your Honor.
All right.
Have a nice day.
Well, we already finished it. Is that finished?
The others, I mean, do I have to? All right, just quick. All right, yeah, because the others are the standard bond that she's already bonded out, and then no requirement for the last 2 for bond. All right, Kenneth Edward Jackson.
He's present in main honor. He's approaching.
Yes, and his attorney's present. Thank you. Please state your name for the record, sir.
Good morning, Your Honor. Ira Carmelin on behalf of Kenneth Edward Jackson.
Last name again?
Carmelin?
Carmel.
Karmelin.
Okay, Mr. Carmel. All right, Mr. Jackson, you were charged with aggravated battery, burglary with assault or battery, burglary on a dwelling structure or conveyance, criminal mischief 200 over 200 under 1,000, and criminal mischief over 200 under 1,000. I have reviewed the probable cause affidavit, and I do find probable cause.
Your Honor?
Yes?
I would like to make a probable cause challenge as to counts 1 and 3. There are probable cause for crimes, but not the crimes stated. On the aggravated battery charge, the only probable cause is for the battery. According to the probable cause affidavit, taking it at face value, Mr. Jackson had a knife in his hand, but struck the person with his fist, not the knife. This is a common pocket knife. In order for it to be a deadly weapon, he has to use it in such a way that it could cause great bodily injury. It was not used in that fashion. Second, as to count 3, the burglary of a dwelling or structure or conveyance while armed, according to the probable cause affidavit, Mr. Jackson simply went into the conveyance, rummaged through it, and took property out. There's nothing in there about him being armed while allegedly burglarizing that conveyance.
State?
Yes, Judge. As to the aggravated battery, defense counsel mentioned that he has to use the weapon in a method in which to injure. He does say that he threatened to kill the victim and then swung at him in the stomach area. Despite the fact that it's a pocket knife, he was intending to use it as a deadly weapon in that case, in that charge. As to the burglary structure, I mean, he's entering the structure, he's taking items from it, and there's no evidence that he's dropped the knife in that case.
And Your Honor, what the state's saying about the knife and hitting in the stomach is an aggravated assault and a separate issue in the probable cause affidavit, because the probable cause affidavit begins with my client allegedly threatening to kill and swinging at Walter Dominguez and hitting it, and Walter Dominguez moves backwards to avoid being stabbed. That would be an aggravated assault. It then goes on to talk about when Mr. Dominguez is where is it? It then says that he punched him in the neck area and shoulder area with a closed fist while holding the knife in the same hand. We are talking at separate acts. So at best, according to what the state's describing, is an aggravated assault, not an aggravated battery.
What I'm reading is that the victim also had to move backwards to avoid being stabbed, which is telling me that the arrestee had the knife in his hand at the time.
Yes, and that would be an aggravated assault, not an aggravated battery. Aggravated battery, he,
is that he had to actually have stabbed him?
yes, ma'am.
That's your position. State.
I mean, if moving further from where Your Honor was just reading, he was punching him in the neck and shoulder area with a closed fist while holding the knife in the same hand.
But that's saying hitting him with a closed fist with a knife in the hand, not trying to stab him. They're two different things.
Well, I'm going to leave that up to the trial judge for you to make that creative argument. At this point in time, I'm finding probable cause, and I am ordering on the, State, do you have any recommendations for, and given, can you let me know what the background is?
Absolutely, Judge. On count number 2, burglary with an assault or battery, that is a punishable by life felony. I'm asking if Your Honor has found proof evident and presumption great to hold the defendant no bond in this case.
May I address the proof evident issue?
Briefly, this is not an Arthur hearing, just so we're
Absolutely.
clear. Okay.
Your Honor, there's confusion in the probable cause affidavit because attached to the documentation, there are 3 victim notification forms, one for a Sergio Akita, Walter Dominguez, and Diego Mengodi. According to the affidavit, the burglary, count 2, is victim number 2. Well, at times victim number 2 is described as Diego Akita, and at another time, Diego Mengodi. We don't even know who's who, because the officer's mixing up names. For that, as the court knows, for the evidence to be, for the presumption to be apparent, the evidence to be there, it has to be greater than probable cause, greater than proof beyond a reasonable doubt, and that's not here.
We've had that debate already as whether it's greater than beyond a reasonable doubt or not, and I have a feeling what State's going to say on their position on that one.
Judge, I think just because the police officer may have messed up the last names here, there's still witnesses that said that he opened the door to a vehicle he clearly did not have permission to open the door to, and then punched the person that was inside of that vehicle.
All right, here's what I am going, do you have any other recommendations for bond? Other than that,
Recommendation
I
would
am
be-
not finding proof evident presumption, presumption high to do a no bond on this. So do you have any recommendations on bond? If not, then I will just proceed
Yes,
with
Judge,
order.
the state would be requesting charge number 1 as a second-degree felony to be $50,000. Charges 2 and 3 first-degree felonies to be $100,000 each.
Okay.
May I address?
Yes, please,
Your
Counsel.
Honor, Mr. Jackson is a lifelong resident of South Florida. He owns a business and employs 4 individuals in that business. He owns real estate, his home in West Palm Beach. To the best of my knowledge, he's never failed to appear for court. He has approximately 20 to 30 relatives in the South Florida area, including his parents, siblings, nieces, nephews, aunts, uncles, cousins, grandparents. He has very strong ties to this community. I would ask that the court set a bond of $3,000 on count 1, 15 on count 2. Because I differ with the probable cause, what the crime is on count 3, I'd ask for $5,000, and I'd ask the court to release him on his own recognizance on the misdemeanors.
Okay, I am finding probable cause on all. I am ordering a $50,000 bond on count 1, a $50,000 bond on count 2, and a $50,000 bond on count 3. I will ROR on count 4 and 5.
So a grand total of 150, correct?
Yes. And also no contact with the victims.
Thank you, Judge.
And no weapons, no knives, no deadly weapons, no anything.
May I approach the clerk for my paperwork? I know in
Yes.
some courtrooms I'm not allowed to while court's in session. I don't want to step on toes.
Okay, we have
You good?
Alright. Alright, Counselor, who are you here for?
Judge, page 12 of your docket, Leslie Lopez, Gary Cole on her behalf.
Okay, I believe that's the one we have no paperwork for, Leslie Lopez?
Yes,
court-
Judge, I have a note as to the same, although from,
Is she in the Maine or is she north?
Judge, the court
I do not
deputy
know where she is.
informed me that there was paperwork now.
Hasn't graced my desk. If there is, if you want to wait and we'll recall and we can try and locate that paperwork. I know you've been very patient, Counselor.
Confinement
Hold on.
status in there anyway.
yes, she's being held no bond on capiases for possession of alprazolam, possession of morphine.
Let me tell you, I can write up the paperwork, but the problem is, she doesn't have a court date. There's another clerk who set the court dates for me, and because there's no paperwork, she doesn't have a court date, so.
I wasn't gonna address the felony. She has a $400 bond on a traffic criminal case. Judge, she's a single mother of one. At the time that she missed the hearing in the traffic criminal case, she was actually living at the homeless shelter on 7th. She now has secured an apartment. I'm just asking if you would release her ROR on the traffic criminal matters only, so she doesn't have to post a monetary bond. She's hired me, I filed my paperwork on Friday, and then she was picked up on the warrants on Saturday.
But are there capias or other outstanding warrants that right now she's not able to bond out on because she has to go before the trial judge, correct?
Yes, Judge, what I'm asking is in the separate traffic criminal case, release her ROR, so when I go in front of the Judge Tobin Singer, she's still not being held on the traffic criminal case, that's all.
Those two cases that he's referring to, Judge, already have capiases by the division judge set at $150 and $250 respectively.
Again, I don't have the authority to interrupt what the trial judge and interfere with what the trial judge has already ordered on bond on their cases. That's the issue. It appears that all phones off.
Sorry, Judge.
I don't have that authority. If the trial judge has already issued a capias and set a bond for that capias, then the detainee has to be brought before that trial judge to address it. It's beyond my scope. Thank you. Have a good day. All right, I think we're back on track now on the regular docket. Terrific. Samantha Elizabeth Woods. She's a what?
All right.
All right. Sorry, Mr. Dessler, I'll get you. Okay. Miss Woods, good morning. Can you hear me?
Good morning.
Okay,
Yes.
You'll need to speak up so I can hear you. Terrific.
Okay.
You are charged with touch or strike, battery, domestic violence. I have found probable cause. State.
Judge, he has no priors. This is the misdemeanor. We would be asking for $1,000 bond and no victim contact.
She has been a lifelong resident of Broward County up until 2016 when she moved to Mason. She was working in Chili's and she could, if she needed to, live with her best friend in Pembroke Pines. So we would ask that court impose no more than $1,000 bond.
All right. I am finding probable cause. I'm going to order $1,000 bond and no contact with the victim.
Okay, thank you.
Thank you. All right. Sabrina Roche Robinson.
President Maine, Your Honor.
Thank you. Mr. Dressler, see, I told you I'd get back with you.
You did, Your Honor.
Been so patient. All right. Miss Robinson, you've been charged with touch or strike, battery, domestic violence, and there's also 2 misdemeanor capiases outstanding. I do find probable cause on on count 1, and there is a status right now on the misdemeanors scheduled for May 11th at 11 o'clock. Those warrant, those K pieces already have bonds issued. State, do you have anything further?
Yes, on count one, Judge, we'd ask you to set a bond of $1,000. There is no priors in this case, but based on the allegations in the report, the blood coming out of the victim's nose, we'd also ask for no victim contact.
Mr. Dressler?
Your Honor, Miss Robinson lives in Dania Beach. She works at a Holiday Inn Express. She's been working there for over a year. She works Monday through Friday. She works starting at 5 a.m. each day. She makes about $900 a month. I'm asking for her to be released on non-monetary conditions on count one, and then count two and count three, or I'm asking for them to be undisturbed. But she could not afford a monetary bond on count one, so I'm asking for non-monetary conditions.
For a company individually, the company, what's the middle provider? Your overall health, good, I'm good. Your mental health problem? No. Ever been in the Army, Navy, Air Force? No.
Alright. She's still gonna have to do the bond for the other two. Alright.
We understand, Your Honor.
Okay, I'm going to ROR on count one, just because of the monetary issue, because she'll have to make the bond on the other two counts to be able to be released. No contact with the victim.
Yes, ma'am.
Thank you, Your Honor.
Alright. Aaliyah Wright? Okay, Miss Wright, you've been charged with violation of injunction protection against domestic violence. It would appear there was an injunction issued that you then subsequently violated. So, I do find probable cause. State?
Judge, she does have a aggravated battery with a deadly weapon pending currently with the same victim in this case. That's where the injunction stems from. We would be asking for a $1,000 bond, no victim contact.
Mr. Dessler?
Dessler, DE, Your Honor.
Yeah, I know. I corrected myself.
No objection, Your Honor.
All
Fill
right,
up the state.
I do find probable cause. I am ordering $1,000 bond and no contact. Ma'am, no contact really does mean no contact. So this
Okay.
order is saying no contact. The last order said no contact. You failed to understand that. Hopefully you will understand on this order, no contact with the victim means no contact. All right, have a good day.
If we may, readdress Sabrina Robinson on the first page of this court's document. It was the case before this.
Oh, what I already signed? Well, okay, we want to go backwards? Okay.
Yes,
What's the issue?
I received a call from my colleagues over at the main jail. We just need a order.
So ordered.
Thank you, Judge.
Not a problem. All right. Gina. Gina.
North Broward, Your Honor.
Pardon me?
North Broward.
North Broward.
North
okay.
Broward.
All right. All right. Gina Mariah. Am I pronouncing that correctly?
Yes.
Okay. You are charged with touch or strike battery, domestic violence. I've reviewed the probable cause affidavit, and I do find probable cause. State. Do you have any position on bond?
Yes, Judge, the defendant does have no priors. We would be asking for a $500 bond, no victim contact.
Okay. Yes.
Yes, this is Ms. Mariah this morning. She's lived all her life in Broward County. She does have significant family contacts. She's a single mother of a 7-year-old son. Your Honor, she just recently had surgery to remove a tumor in her left breast, and that tumor is undergoing a biopsy. Your Honor, based on that and her ties to the community and the fact that she's not able to work right now, we would ask the court for a non-monetary bond for pre-trial release.
Okay. I'm going to order pretrial release violence and no monetary bond and no contact with the victim. I understand the victim is one of her relatives, correct?
Yes, sir.
Yeah, so no contact with your sister, okay? But I am gonna do the pretrial, no monetary, okay? Yeah. All right. Cody Bryant Slaughter.
Present, Your Honor.
All right. Mr. Slaughter, you are charged with touch or strike, battery, domestic violence. I've reviewed the probable cause affidavit and find probable cause. State, do you have any position?
Yes, yes, Judge. The defendant does not have any priors. We would be asking for a $1,000 bond based on the allegations and the probable cause.
Mr. Dessler.
Your Honor, Mr. Slaughter has family down here in Fort Lauderdale that he can stay with. Unfortunately, though, he's currently unemployed. Because of that, he does not have any money to be able to bond out. I'm asking for him to be released on non-monetary conditions, Your Honor.
All right. I'm going to, is he working right now?
No, he's unemployed right now, Your Honor.
But he does have a place to stay.
He has family in Fort Lauderdale, yes.
So there's an address that we will have to make sure that he shows up where he needs to show up.
Yes, Your Honor.
All right, and that will be provided so that we have that. Okay.
Yes, Your Honor.
All right, I'm going to... I'm gonna ROR on count 1 with no contact with the victim.
Oh, I got alert.
Thank you, Your Honor.
Thank you. Down the middle, outside.
Pretrial takes TV, do they?
Oh,
Does pretrial take TV? He lives out of the county. Okay, but pretrial takes TV?
Yes, upon your request, Your Honor.
Oh, all right, thank you. He's doing. Good thing I'm finding that out early. All right. Chinello Leonard Osuji?
he's present, Your Honor. He declined the services of the public defender.
Okay, Mr. Osuji, that is your prerogative. You are currently charged with touch or strike, battery, domestic violence.
Mr. Baxter?
I have
Yes, Your Honor.
I've read the probable cause affidavit, and I do find probable cause. State, do you have a position?
He does have some juvenile priors, Judge, as well as a 2015 petty theft. We would be asking for a $1,000 bond and no victim contact.
Okay, sir, how long have you lived in Broward County?
At least 10 years.
Okay, do you, and you presently still reside here, correct?
Yes, Your Honor.
Okay, are you working?
No, not at the moment. I'm currently enrolled in school.
Pardon me?
I'm enrolled in school.
Okay, you're a student. What school?
Broward College.
Okay. All right, I am going to order pretrial without a monetary bond and no contact with the victim. Sir, that means no contact, no text, social media, third party, no contact, all right? Thank you, have a good day. Hadley James Augustin.
North Broward, Your Honor.
Pardon me?
North Broward.
North Broward.
Thank you. All right, Mr. Augustin, you are currently charged with touch or strike, battery, domestic violence. I've reviewed the probable cause affidavit. I do find probable cause. State, any priors?
There is a pending criminal mischief in Judge Diaz's division, Judge. Other than that, there's no priors. We would be asking for a $500 bond, no victim contact.
Okay.
Minor, Mr. Dustin has lived in Broward County for 3 years. He lived in Miami-Dade County prior to that. He would be able to stay within Cooper City. I understand this is an issue where he was living with his brother and his father. He is working, works at a funeral home, Your Honor.
He's currently working?
He's currently working.
Okay.
Yes. And the funeral home is in North Miami Beach. We just would ask that he be allowed to travel to Dade County for purposes of work. And, we would ask for no monetary bond. He would stay with his bond.
Okay. Okay, I'm gonna order pretrial, no monetary bond. I'm gonna allow him to travel to and from Miami-Dade County for work purposes only, and no contact with the victim.
Judge, did you find probable cause in this one?
Yes, I thought I had said that right off.
I'm sorry.
But, okay, yes, I find probable. If I don't expressly state it, that I don't find it, I'm finding it.
Okay, I understand.
Okay, just so it's clear. All right.
That's it. That's it.
That's it. Philip Diaz Album?
Present, Your Honor.
All right. Mr. Album, you're charged with touch or strike, battery, domestic violence. I've reviewed the probable cause affidavit, and I do find probable cause state. Any priors?
He has a prior domestic violence case with the same victim, Judge, so the state would be asking for a $1,000 bond.
Okay. Mr. Dessler?
No objection to the $1,000 bond, Your Honor. I am asking for an order for my office to be able to take photos of Mr. Alvin.
Okay.
He has injuries.
All right. I am finding probable cause. I'm going to order a $1,000 bond on count one. I also will enter an order allowing photos and no contact with the victim. Thank
you, Your
you.
Honor.
All right. Angel Alejandro Lopez Pereira.
He requires a Spanish interpreter, Your Honor.
Spanish interpreter. See, you knew why you came in.
Spanish interpreter is present. Luis Angela Lopez, Your Honor.
All right. Good morning, Mr. Lopez Pereira.
Buenos días, señor López Barrera.
You are charged with touch or strike, battery, domestic violence.
Señor, lo acusan de tocar o pegarle a alguien de agresión física en violencia intrafamiliar.
I find probable cause state.
Encuentro motivo fundado para detenerlo, señor.
Any priors?
No priors, Judge.
La fiscalía, la señora juez pregunta al señor fiscal si hay antecedentes penales. La fiscal dice que no.
Any recommendations? Do you have any specific recommendations?
¿Hay alguna recomendación específica por parte de la fiscalía?
The state would be requesting a $1,000 bond.
Sugiero que impongan una fianza de $1,000.
Okay, Mr. Dessler.
Your Honor, Mr. Pereira has lived in Broward County for 4 years. He has a family down here. He's an electrical engineer. He makes about $400 a week. He has no record, but because he's only making the $400 a week, he's unable to post a monetary bond. I'm asking for him to be released on non-monetary conditions.
El señor abogado allá presente le dice a la señora juez que usted ha vivido en la Florida por 4 años, que tiene toda su familia, que es un ingeniero eléctrico, y que usted gana $400 a la semana, que usted no tiene antecedentes penales y que debido a que solo gana $400,000 a la semana, no puede pagar una fianza alta. Le pide a la señora juez que por favor, I'm so sorry, Your Honor, may the interpreter request counsel repeat the monetary bond that he requested.
I'm asking for no monetary conditions.
Que por favor no le imponga una fianza para dejarlo en libertad. Thank you, counsel.
Okay, I am ordering pretrial with no monetary bond and no contact with the victim.
Le impone que lo dejen en libertad bajo los servicios especiales de la corte. No tendrá que pagar una fianza, pero pasará con esos servicios especiales de la corte. No debe tener contacto o comunicación con la víctima.
Thank you, Your Honor.
All right, have a good day.
Yeah.
Jorge Luis Rodriguez.
I'm so sorry, what page is
Present, Your Honor.
Page 2, bottom.
I'm sorry?
Bottom of page 2.
Page 2. Okay, thank you. Does he need Spanish?
I don't know, we'll find out. Mr. Dessler, does he need a
He's present,
Spanish-
Your Honor.
Does he need a Spanish interpreter?
No, he understands English, Your Honor.
Okay. Just wanted to know if she could leave the podium.
Thanks, yeah.
Okay. Mr. Rodriguez, you are currently charged with touch or strike, battery, and domestic violence. I've reviewed the probable cause affidavit, find probable cause. State, any priors?
No priors, Judge. The state would be requesting a $1,000 bond based on the allegations and no victim contact.
Okay. Mr. Dessler?
Your Honor, Mr. Rodriguez has lived in Broward County for 30 years. He lives in Plantation. He is a food distributor. He's been doing that for a number of years. He makes $19 an hour. However, for him to stay away from the wife, he's going to need to rent a hotel room. He doesn't have other family or friends down here that he can stay with. And he understands he needs to stay away from the wife in the short term. But because he's going to have to rent a hotel room, he's not going to be able to afford both a monetary bond and a hotel. So I'm asking for him to be released on non-monetary conditions so he can afford a hotel room in the short order.
Okay. I am ordering pretrial with no monetary bond and no contact with the victim. Sir, that means no contact. Social media, third party, or otherwise. Oh, okay. Oh, that's going to be an issue, isn't it? All right, because of the hotel, he doesn't know where he's going to be, and I don't want that to tie it up. Okay, I'm not going to do pretrial because right now he'll sit in jail until he knows what hotel. I don't want that. So I'm going to ROR him. Mr. Hawker, you have something to say? I'll sign a photo order as well. Mr. Dessler and Mr. Rodriguez, I'm ordering ROR. And that means you need to show it for your appearance, but you'll need to provide to the court the address where they can notify you, okay?
Thank you, Your Honor.
And no contact with the victim. I'm not ordering pretrial because that will just tie up your release. All right.
Judge, there's a discrepancy in one of the cases we did. Philip Alvim, I had written down that you had held him on a $1,000 bond, and I'm finding the clerk wrote ROR on it. Alvim, Alvim.
Yeah, it was 1,000. It was 1,000.
Okay.
I'll correct it.
Thank you, clerk.
Thank you, clerk.
Okay. And you got that order for photos, right?
Yes, I submitted it.
Okay, just want to make sure. All right, Frankie Lang Fisher.
Present, Your Honor.
Mr. Fisher, you've been charged with touch or strike, battery, domestic violence. I find probable cause. State, any priors?
There is a 2002 delivery of cannabis for consideration, a third-degree felony, as well as some juvenile priors. The state would be requesting a $1,000 bond and no victim contact.
Mr. Dessler.
Your Honor, Mr. Fisher, he could live with his mother in Fort Lauderdale. He's lived in Broward County his entire life. He works at a Dollar Tree. Unfortunately, though, he only works part-time. He works the overnight shift, so he's only making about $600 a month. And he only started work a little more than a month ago, so he has no current savings. I'm asking for him to be released on non-monetary conditions, and he would be staying with his mother.
All right, I'm going to release ROR with no monetary bond and no contact with the victim.
Thank you, Your Honor.
All right, Joseph Calderon.
Present, Your Honor.
Mr. Hawker.
Yes, Your Honor. We may be heard as far as probable cause.
Okay. Can I tell him the charges first and then you? All right, Mr. Calderon, you are charged with touch or strike, battery, domestic violence. Mr. Hawker, you have something to say regarding probable cause.
Yes, Your Honor. Reviewing the probable cause affidavit, going on the first page, leading over to the second page, so the victim stated that the arrestee, she and the arrestee never got into a physical altercation, that they either broke the aggressive towards her. Your Honor, on the last page of the affidavit, it says that the victim began advised that the first time she was on scene earlier today, she didn't advise him that the arrestee did in fact push her to the ground. Given the fact that the victim is giving conflicting accounts of what happened, and while the officer was on the scene, at the present time, stating that she never got into a physical altercation with him, we would ask this court not find probable cause for such a strike matter, given the fact that the victim's statements during the first time that the officer arrived.
Okay. State?
Yes, Judge. On the last page, it does say that the arrestee did in fact push her to the ground. The victim showed me a bruise she did have on her leg, which she stated she suffered from the first incident. I'd also argue, although it wasn't charged, it seems like aggravated assault with a deadly weapon in the sense of he's trying to run her over with a vehicle. So I would ask Your Honor to find at least probable cause for the touch or strike battery based on the allegations he did push her to the ground and she had a bruise on her leg from that first incident.
Well, here's the issue with that. Further down, it also states that the allegation was the arrestee jumped out of his vehicle, grabbed a metal tire rod, and began waving it at the victim in the vehicle. So I'm going to give the state 24 hours to correct or to perfect the probable cause affidavit as to what you want to do with the charges, given both what you've stated on page 3, and also regarding the use of the vehicle and the use of the tire rod, which appears not to have been addressed. So I'm going to give you 24 hours to perfect. And
May we discuss a monetary bond on the
on
the charge of battery?
On the charge of battery. Okay, Mr. Dessler, remind me, yes, your position.
Your Honor, Mr. Calderon, he lives apart from the victim. He lives in Hialeah, actually. He's lived in South Florida his entire life. He works as a dispatcher for a courier service. He makes about $300 a week. I would ask for a bond to be set at $1,000. If Your Honor does set a monetary bond, I would ask for a phone order just so he can get into his property and access his phone, so he can call his family, so he can actually post the bond.
Okay. I am going to order $1,000 monetary.
Judge, there are many priors I'd like to put on the record.
Oh, yes.
There's a 1990 burglary of an occupied dwelling, which was null pros, but Your Honor can take into consideration. 2004 domestic violence, which was null pros with a different petitioner. 2004 battery and false imprisonment, which were withholds. 2005 domestic battery, which was a null pros, a prior domestic violence case in Miami with a different petitioner. A 2010 battery, false imprisonment, aggravated assault with a deadly weapon, which wound up being null prost, and a 1999 battery, which wound up being null prost. It seems he has a history of violence, whether they actually come to fruition in a trial or not, and the state would be asking for higher than $1,000 bond. We'd be asking for a $2,500 bond based on the history. No victim contact.
Okay. All right, I'm going to order $1,000 bond. I'm also gonna order no contact with the victim and batter's intervention. It appears that the history of domestic violence, maybe that might be helpful. And state's gonna be, already we have state perfecting for count 1. Okay?
Thank you, Your Honor.
Thank
Are
you.
we perfecting? Judge, just to, I'm so sorry to bother you.
Okay.
Are we perfecting on count 1, or are we perfecting as to the potential aggravated assault with a deadly weapon?
Oh, correct. All right.
Because I do believe there's probable cause to at least find a misdemeanor battery.
All right. Yeah, I am finding probable cause on count 1. You have 24 hours to perfect any additional charge.
Thank you, Judge.
All right. Jeremiah Lee Baxter.
I'm sorry, Judge.
Oh, I'm sorry.
I don't understand. You say mine probably?
Yes. She's perfecting on the allegations in the PC that appear to be aggravated battery with the car and the tire rod. I understand.
I believe the state's going to leave that up to the filing attorney if they want to do add charges in the future.
Okay, so you don't need perfected.
No, because as long as you're finding probable cause for the arrested charge.
Fine. All right. Did you get all that, Mr. Dress?
Your Honor, I have Mr. Baxter here on page
Okay,
4.
hang on there while the clerk has
Okay.
one question. Yes. Okay, you don't want to?
It's, I haven't heard of it done in magistrate. Yes, it's normally a condition
Okay,
of someone's
fine.
probation or release.
Fine. Fine. I can go with that. All right, Mr. Baxter.
Present, Your Honor.
You are charged with domestic battery by strangulation, aggravated battery, offender knew or should have known the victim was pregnant, and touch or strike battery, domestic violence. I have read the probable cause affidavit, and I find probable cause state. Do you have any priors?
Yes, Judge. In 2013, a stalking violence, which was ultimately null pros, and a 2013 domestic violence battery, which was ultimately null pros. The state would be requesting a $5,000 bond on charge number 1, a $7,500 bond on charge number 2.
Mr. Dessler.
Your Honor, Mr. Baxter, he lives in Wilton Manors. He's lived there for 2 years, but he's lived in Broward County for a total of 15 years. He works at Walmart. He's been working there for about 1.5 years. He makes about $10 an hour. He can live with his brother, and Mr. Baxter has no savings. He can't afford any monetary bond. I would ask for him to be released on non-monetary conditions if possible. Or I would ask Your Honor to lower what the state's recommendation was, because Mr. Baxter has no means of making $12,500 bond.
All right, well, I am going to order a $1,000 monetary bond on count 1, no monetary bond on count 2 and 3, and no contact with the victim.
So ROR on 2 and 3.
Oh, ROR on 2 and 3?
Well, no monetary, but yeah.
Okay.
But what did I say? On 1.
Thank you, Your Honor.
The clerk will translate for me. All right. Jermaine Parkinson.
Conti, Your Honor.
Thank you. Mr. Parkinson? There's nobody at Conti. We sure he's at Conti?
Your Honor, I'm being told he's en route to Conti. He's no longer in Maine. He might not have gotten into Conti yet. That's what I'm being told by the officers here.
Okay, we'll put him on recall. Here, hold recall. All right. Shanita Neal Cole Conaway?
North Broward, Your Honor.
North Broward. Are you reaching for these? All right. Miss Conaway.
Yes, how you doing, Your Honor?
Good morning. See, she knows how to speak up so I can hear her. All right, Miss Conaway, you are charged with trespass. I've read the probable cause. I find probable cause state.
Judge, this is a municipal ordinance, so the state wouldn't even be prosecuting it.
Oh.
She does have some drug priors.
Okay.
Sure do.
Pardon me?
I say sure do.
Okay.
She's not lying.
All right. All right. And yes, please, Mr. Hawker, as a friend of the court, it would be appreciated.
I spoke to Ms. Conaway this morning before realizing it was a municipal ordinance. She does say that she lived in Broward County for 37 years. She does live with her mother, and she currently receives disability for mental health issues. And we would ask the court to take that into consideration and perhaps releasing her on recognizance.
All right. She does have a place to live, Mr. Hawker?
Yeah, she said she lives with her mother in Broward County.
Okay, ma'am, you're living with your mom?
Yes, I am. My mom, my family, my mom, sisters, and brother.
Okay. All right. Ms. Conaway, I am going to release you on your own recognizance.
Thank
Okay?
you.
Ma'am, listen carefully. You are not to go back to the location where you were arrested. Do you understand? You can
Yes, I do,
address your
ma'am.
charges before the trial judge, but until that time, ma'am, while you are on release, do not go back to that location. It will
Okay.
just result in further violations of your pretrial.
Okay.
Okay? Do we understand each
I
other?
understand.
Terrific.
Yes, I understand fully.
Okay.
Because they're gonna.
Have a good day, ma'am.
You too.
Jerry Strevel?
No problem.
Yes, Your Honor.
Okay, Ms. Strevel. You have been, all right, you have multiple capiases.
Yes, Your Honor. Now, I wanted to say, the
Ma'am-
one in 2008.
Ma'am,
Okay.
if you didn't hear or weren't present or didn't listen to what I initially said when I gave my opening colloquy, this is not the trial. I am not the trial judge. You should not talk to me about the facts of your case, whether, to tell me why you didn't do what you're alleged to have done, all right? You have,
okay,
right
that's fine.
now, you were picked up on various capias warrants for your other charges. So I'm finding probable cause based on the outstanding capiases. All right?
Okay, yes, you can.
Now, your trial judge in those misdemeanor charges has already set bond. So I'm not going to disrupt that. I don't have that authority to disrupt that. Those have already been set, those bonds on your various capiases. You have a status scheduled in front of your trial judge on May 22nd at 2 p.m. If you wanted to bond out the capiases for the various cases, your 08 case has a $250 bond, your 3 2017 cases respectively have 500, 100, and 100. Those are your bonds already set by the trial judge. Do you understand, ma'am?
Okay, so I'm not going to be released today?
You would need to make bond on what the trial judge already ordered, which total right now $950 bond. Did I get my math right for all four?
750, 850, 950. Yes.
I got it spot on. Yes, 900 total for all four capias warrants would be $950. Okay?
Oh,
So
okay.
that's the trial judge, and I have no authority to disrupt that. All right, have a good day, ma'am.
Okay, yes, Your Honor.
And I did find probable cause based on the warrants. All right, Jacqueline Seraphin.
President Maine, Your Honor.
All right. Miss Seraphin, you have been charged with DUI with damage to property, person, or person of another. Safety, I do find probable cause on the affidavit. Safety, you have priors.
No priors, Judge.
Mr. Dessler, you have a position on bond.
Your Honor, Miss Seraphin lives in Delray Beach. She's lived there for 3 years. She's lived in South Florida for a total of 17 years. She works as a hairdresser. She's been doing that for 17 years. She has a brother that lives down here, but she can't make contact with him. She doesn't know his phone number, and her phone is not in property here at the jail. So she has no way of actually posting a monetary bond, unfortunately.
My phone is here, but it's dead.
And or her phone is here. It's just that it's dead. She doesn't have. She won't be able to use the phone. I'm asking for her to be released on a non-monetary bond, just because she has no means of actually posting a bond.
Does she have an address where she's going to be living?
Yeah, she resides in Delray Beach. She has an address.
Okay, pre-trial? But you're not able to verify her?
We're able to contact the contacts.
Oh, okay, Mr. Dessler, here's the situation, even if I did pre-trial, pretrial with no monetary. Right now, pretrial's not able to verify that residence. They haven't been able to reach. So I don't know.
Miss Seraphin, she claims that she has an address. She's giving me the address.
Oh, I know, but they need to verify, and I guess they're trying to call and they're not getting any.
She says it's the address that's on her driver's license, and that's where she resides.
I don't think the actual address is the issue, Mr. Dessler. I think pretrial, I think it's that you just can't reach that address, the residence at that address to confirm she can stay there.
I mean,
that's the issue.
Your Honor, what I would say is if she is released on pretrial and there is an issue with pretrial being able to reach her, and more importantly, if Ms. Seraphin does not appear for court, the remedy in place is that there will be a warrant out for her arrest. That there is a remedy in place even if she is released on pretrial.
No, I understand, Mr. Dessler. I guess from what I'm being explained by pretrial. Okay, can you hear me? All right. From what, if you are talking, you can't listen. So
I was just asking if anybody lives there. She says her brother lives there. She just doesn't have the phone number to reach him because her phone's in property here, but the phone's dead.
Okay.
So she can't.
All right. Here's what I'm going to do. I'll order pretrial.
Okay.
No monetary bond. And what you'll understand is it's going to be pending verification. So
Okay.
As soon as pretrial can do what they need to do, they will address it. Okay?
Thank you, Your Honor.
Have a good day. Sheena Lynette Carter.
Hold on, Your Honor.
Hello. Oh, okay. Good morning. All right.
Good morning.
Miss Carter, you were picked up on an outstanding capias on a prior misdemeanor charge.
Yes.
Okay. So you have, right now, that is before the trial judge, and you have a status scheduled for May 9th at 1:30. There is no, is that at my discretion, because there's no bond on the warrant?
No, it's being held, she's being held no bond.
Gotcha. All right. Miss Carter, because the capias has a no bond on it, meaning the trial judge determined when they issued the capias warrant to pick you up, that they were not issuing a bond on that. This court has no authority to disrupt that, so you will have to address that with the trial judge on May 9th at 1:30. I do find probable cause based on the outstanding capias. Thank you. Have a good day. Derenique Peaches Johnson.
President Maine, Your Honor, she declined the services of the public defender.
All right, that is your prerogative, Miss Johnson. Okay, you are charged with petty theft, second degree, your first offense.
Yes, ma'am.
Okay.
Your Honor, she's currently out on pretrial for case number 17003504, CF today for grand theft auto.
All right. Miss Johnson, did you hear that?
Yes, ma'am.
Okay,
I was, because
okay, ma'am.
I have.
Ma'am,
Sorry.
as you heard my earlier colloquy that said, don't give me the facts of your case because everything's being recorded and it's going to be used against you in future trial. So is that what you want to start telling me, the facts of your case?
No.
Okay.
I was telling you that I have 3 kids to send home to, that I have schools, and my mom has work, and it's kind of tough. So.
I'm sure it is, ma'am, which maybe you should have thought of that before all this happened. So, ma'am, I am going to revoke your pretrial, and when is her next date? Does she have a date that she's going before her? All right, now?
Yeah, I'm gonna call you in a second.
So the first offense was petty theft, and now this is second offense, pretrial, ma'am? Sorry, so the first offense, the offense she was on pretrial was petty theft?
Grand Theft Auto.
Grand theft auto.
Felony grand theft.
Oh, okay. That was the first, and then this is, she picked up the new. All right. All right, ma'am. I am. State, do you have anything to offer as far as?
I mean,
And
she,
Your Honor, I don't have enough money to afford for a bond. I was going to ask, can I have an ROR, please?
All right, hang on.
the standard bond is $25 on the second degree petty theft. She does have prior petty thefts as a juvenile, 3 of them, and then the pending Grand Theft Auto is pretrial, as
All right.
let you know about.
All right, well, pretrials revoked, so that means.
On the grand theft auto, it's at your discretion. No bond or, it's at your discretion for the grand theft auto.
right, there we go.
There we go.
I can hear you
Sorry,
now.
yeah, okay, that was, the thing is, I'm technologically challenged when it comes to this little screen thing here, so.
Right.
The right buttons weren't pushed, and I wasn't getting assistance here and getting them. All right, so, ma'am, here's the situation. And this is more focused right now because of the children at home situation. I am going to rescind my previous revocation of your pretrial on your grand theft. I am going to you're going to be still on pretrial with your grand theft. I am putting you on additional supervision with pretrial for your petty theft. Do you understand me? I'm not going to add an additional monetary bond, but ma'am, you need to strictly comply with pretrial reporting
Yes, I
and
do.
doing everything that you need to. Do you
Yes, I do.
understand me?
Yes, ma'am.
Okay. All right. Aaron Greg Kavanaugh.
President Maine, Your Honor.
Thank you. Oh, okay, Ms. Kavanaugh, you are charged with DUI, alcohol or drug first offense, DUI.
It's that her breath alcohol level was over a 0.15, like an
Thank
enhanced.
you. All the little acronyms. All right. Count 3, DUI with damage to property or person, and count 4, failure to use due care. Mr. Harker, do you have a position since you're standing up?
Yes, Judge. Reviewing the probable cause affidavit with respect to count 3, this is saying that it ran into the back of another vehicle. There's no description of that vehicle. There's no mention of being in conversation with the driver. Hence, there's no indication that that vehicle was damaged. I believe there is no probable cause for count 3 DUI with damage or property to person or another.
State.
Judge, it says she was involved in a motor vehicle accident. This isn't a civil case where we have to prove a certain amount of damages, a number of sorts. When they arrived, the defendant's still sitting in her vehicle. So there's obviously actual physical control of her being in the vehicle. There's an accident investigation that takes place. I believe there is probable cause for a DUI with property damage.
Your Honor, that's correct. It's not a certain level, but there has to be some evidence that there's damage there. The probable cause affidavit doesn't say there's any evidence that there's damage to the other vehicle,
It says she ran into the back of another vehicle.
but it does not indicate the damage there.
Okay, state, we're in here. I mean, running into it and having actual damage are two different things. I'm looking at it. Did I miss something?
She was involved in a motor vehicle accident when she ran into the back of another vehicle.
Did either that or I can give you 24 hours to perfect, to find out if there was actual damage for count 3. Because running into the rear end of a vehicle, depending on, may or may not result in actual damage under the statute.
The state would ask for 48 hours to perfect that count.
Okay, you'll have 48 hours to perfect count 3. I do find probable cause for count 1, 2, and 4. State, do you have information on any priors and recommendations or suggestions on bond?
No priors, Judge. We would just ask the standard bond amounts.
Mr. Dessler.
Your Honor, no objection to the standard bonds on count 1 and 2, and just to clarify, so she'll be ROR'd on count 3?
She'll be ROR'd on count 3, and count
Okay.
1 will have a bond of $500, and count 2 will have a bond of $1,000, and also no alcohol.
No objection to that, Your Honor. The only other request I have is if Ms. Kavanaugh can access her property so she can get her cell phone, so she can have her family post the bond for her.
So ordered.
Thank you.
Oh, I gave you a, I don't have anything. Oh, I'm sorry.
Okay.
All right. Maria Posada.
She's present, Your Honor. She requires the services of a Spanish translator.
We have one here, ready, willing, and able.
She declined the services of the public defender because she said she's hired a private attorney, or her husband hired a private attorney.
Okay, has he been contacted? Do we know? All right.
Señora, buenos días. El señor abogado allá presente le dice a la señora juez que usted no desea tener que le asignen el abogado de oficio debido a que usted o su familia han tratado de contratar a un abogado privado. Your Honor, may Your Honor repeat the question?
Okay, has your attorney been contacted already to know that you were appearing in court today?
¿Se han comunicado con el abogado que contrataron para ver si él sabe que tiene que presentarse hoy a representarla?
No he podido hablarme con él todavía porque no tengo el teléfono y mi marido es el que sabe el teléfono de él. Tendría que llamar a la casa para contratarlo a él. Él se llama Barry.
¿Perdón, señora?
Él se llama Barry y...
Un momento, señora. I have not been able to contact the attorney because I don't have a phone with me, either to call my family, but if I can contact them, his name is Barry.
All right, let me go over the charges, and maybe if Mr. Dessler needs to be a friend of the court, he will. Okay, Ms. Posada, you are currently charged with DUI, alcohol or drugs first offense, DUI with blood alcohol over 1.5, DUI with damage to property or person, and count 4, failure to drive in a single lane.
La acusan en este momento de estar conduciendo bajo los efectos de alcohol o drogas. Es el primer delito, la primera vez que la acusan de esto. También la acusan de estar conduciendo bajo los efectos y donde le podrían añadir penas adicionales debido a que el nivel del alcohol es de más de 1.5. También causando daños a la propiedad. I am so sorry, Your Honor, but the last part, Your Honor.
I don't know what you mean, the
damage
last
to
count?
property. Damage to property.
Okay, and count 4, failure to drive in a single lane.
So
No problem.
Y la cuarta acusación es de no cumplir con permanecer en un solo carril.
Okay. Now, ma'am, I've reviewed the probable cause affidavit, and I do find probable cause for your arrest under all counts.
I'm so sorry. Go ahead. He revisado el affidavit de motivo fundado y encuentro motivo fundado para detenerla en cuanto a las 4 acusaciones.
¿Me va a detener?
Am I going to be detained?
Well, ma'am, here's the thing. What I've tried to ascertain from you and try to get is, have you actually hired the attorney, or are you in the process of needing to call an attorney to hire an attorney?
Señora, la pregunta que le he hecho y lo que he tratado de averiguar por su parte es que acaso usted ya ha contratado un abogado o es que usted solo está en el proceso de buscar un abogado y contratar un abogado.
Yo no lo he contratado todavía. Voy a hablar con él. Voy a hablar con él, pero es que no tengo el teléfono ni de él, ni tengo mi teléfono.
Un momento, señora. I have not contacted an attorney. I would like to talk to an attorney, but I don't have my phone to talk to an attorney.
Okay, so, as a friend, okay, stay.
There are no priors, Judge. We would just ask for the convenience bonds that have already been set.
Okay.
La fiscalía habla, señora juez, la acusada no tiene antecedentes. La pediría que le impongan la fianza normal que él siempre le impone.
Okay.
Okay. All right, ma'am. How long have you lived in Broward County?
Señora, ¿cuánto hace que vive en el condado de Broward?
21 años.
21 years.
Okay. Are you currently working?
¿Está trabajando en la actualidad?
Trabajo para el school board.
I work for the school board.
All right. I am going to order a bond of $500 on count one.
Le voy a imponer una fianza de $500 para la primera acusación,
$500 on count two.
$500 para la segunda acusación
And $500 on count three.
y $500 para la tercera acusación.
I am also ordering no alcohol while you're on release, pre-trial. And I'm going to order pre-trial release.
No debe consumir bebidas alcohólicas mientras que usted esté bajo libertad. También voy a ordenar que usted salga en libertad bajo los servicios especiales de la corte.
And I'm going to enter an order that you can have access to your personal property to get your phone so you can make the call to contact whoever you need to make bond.
Y también voy a firmar una orden para que le den permiso de usted a poder ir a buscar sus propiedades para que usted pueda llamar a alguien para ver si le puede pagar esa fianza.
Mi esposo para salir me dijo que él puede pagar 250.
¿250?
Sí, mi
To be
esposo.
able to be released, my husband is able to pay $250 bond.
To get out, porque la fianza total son 2.500, ¿no?
Because the total amount for bond would be $2,500?
No, be $1,500.
No, serían $1,500.
Pero hoy mismo, today,
Do I pay that?
Oh, yeah.
Do I pay that today?
Work that out with the bondsman, ma'am.
Señora, si usted va a pagar esa fianza, usted puede hablar con un fiancista.
es que quiero, a ver, ya, porque, pero puedo salir hoy.
May I leave, will be released
Espera un
today?
momento, porque
Once
pues me dijeron,
ma'am.
Señora, un momento, por favor.
Once you post the bond I've ordered, then you would be released.
Una vez que usted haya pagado esa fianza que yo ordeno, usted podrá dejar salir en libertad.
Okay?
¿De acuerdo?
Perdóneme, pero ¿cuánto tengo que pagar hoy?
I'm sorry, but how much do I have to pay today?
Okay, Mr. Dessler, thank you.
We're going to explain it to her.
Friend of the court, can you please explain how bond
We're going to
works?
explain it to her. Here, we have a Spanish speaker here. We're going to explain it to her.
Dice el
So
señor
you'll
abogado allá
explain-
presente.
We're going to explain it.
You'll explain how bond works. It's
We
$500
will,
for
thank you.
each count, and
Yeah.
I'm entering an order that she can access her phone to make those arrangements.
Señora,
Thank you, Your Honor.
la señora juez está hablando con el señor abogado y le dice,
And she's on pre-trial.
y le dice a la señora juez que él le va a explicar a usted con el señor que habla ya español para explicarle lo de las fianzas y que usted va a salir en libertad bajo esos servicios especiales de la corte.
And once you're released, ma'am, you need to report immediately to pre-trial.
Y una vez que a usted la dejen en libertad, usted se tiene que presentar inmediatamente ante esa oficina de los servicios especiales de la corte.
If you're released, ma'am, that means that if you're released today, you report tomorrow. But if you're released tomorrow, then you report tomorrow to
Eso lo que
pre-trial.
quiere decir, señora,
All
es
right.
que si a usted la dejan en libertad hoy, usted irá a presentarse a su oficina mañana, temprano en la mañana. Pero si la dejan en libertad mañana, usted irá inmediatamente a esa oficina a presentarse allá.
All right, thank you, ma'am. We're concluding.
Thank you.
Gracias, señora.
Thank you. Thank you.
That Jermaine Parkinson has arrived at Constance.
Is that the hold? Yes. All right.
All right, she's gonna do that first. Come on.
It's just going to be a hold.
Which one's the fresh water? This one? That one, okay. He's a Conti?
Yes, sir.
All right. Mr. Parkinson,
Good morning.
good morning. All right. Were you present for the colloquy that I explained to everybody else about what this hearing's about?
I understand what that is.
Okay, so you understand that this is not your trial. You're here just for me to ascertain whether there was probable cause for your arrest and whether there's pretrial release or not, depending on the circumstances and as far as counsel goes. Okay?
Correct.
All right.
Mhm.
So you basically were picked up on 2 out-of-state hold felonies, and you are subject to an extradition to what counties?
This is Texas, Judge.
Harris
Texas. Okay. So we basically, I found PC based on the outstanding warrants. We're not going to have any hold here or any bond here. Any bond here, because we're going to just hold you for Texas to come and pick you up.
Okay.
Understand? So you're
Yes, ma'am.
basically held with subject to Texas coming for extradition.
And they have 30 days, correct?
Well, he has to have his extradition hearing, and that will be
That I'm being told is next week.
Tuesday, May 9th.
Okay. Pardon me?
It'll be Tuesday, May 9th, or Thursday.
Okay. Sir, this week you're scheduled to have an extradition hearing. And at that time, the judge will let you know and you'll be able to talk to the judge, okay? But you're being held
Understood.
for extradition, all right? Have a good
Okie
day,
dokie.
sir.
Likewise. Have a good
All
day.
right. Kathleen Renee Hammett,
No, bro, Johnny.
North Broward. All right, Miss Hammett.
Yes, ma'am.
You've currently been detained due to an outstanding capias on your misdemeanor. And that, your trial judge had set a $250 bond on that. You have a status before your trial judge on May 9th at 11 a.m. This court has no authority to disrupt that, nor will it. So, your bond on your capias is $250, ma'am, and then you are scheduled for your status on that case on May 9th. Okay? Have a good day.
Okay. Thanks.
Sandra Marlene Barrero.
Yeah, good morning.
All right, Your Honor. She needs a Spanish interpreter.
All right, good morning. Spanish
Good
interpreter
morning.
racing to the podium.
Good morning, Your Honor. Again, the interpreter is present.
Okay. Miss Barrero, you are currently charged with toucher strike battery, domestic violence, toucher strike battery, and burglary, occupied conveyance, unarmed.
Señora Barrero, en este momento la están acusado de tocar o causar agresión física a alguien. La segunda acusación es de tocar o pegarle a alguien. La tercera acusación es de entrada ilícita con fines delictivos a un medio de transporte que tenía sus ocupantes y usted no tenía un arma.
Okay. I do find probable cause state. Do you have any priors?
Encuentro motivo fundado.
No priors, Judge.
La fiscalía informa no hay antecedentes penales.
Miss Barrero, how long have you lived in Broward County?
Señora Barrero, ¿cuánto hace que vive en el condado de Broward?
21 años.
21 years.
Okay. And okay, it appears the incident occurred between you and your husband.
Según parece, el incidente que ocurrió fue entre usted y su esposo.
Sí, señora.
Yes, ma'am.
And
there's another victim as well, Judge.
También hay otra víctima, dice la fiscalía.
And
Sí, señor.
the other victim is the
potential mistress, Sandra Ramirez.
Quizá una amante, Sandra
All right.
Ramírez.
Sí, señora.
Okay.
Yes, ma'am.
do you up until this, do you currently reside in the same household with your husband?
En este momento, hasta ahora, en la actualidad, ¿usted está viviendo en la misma en el mismo hogar con su esposo?
Sí, señora.
Yes, ma'am.
All right, so all right, you said there's no priors?
No priors, Judge.
No hay antecedentes.
Yeah, also present is Ms. Burrell's daughter. That's the young lady standing in blue.
También está presente aquí en la corte la señora hija de la señora Barrero.
All right, so if mom is released, where's she gonna stay?
Si a la madre la dejan en libertad, le pregunta a la hija, ¿dónde va ella a ir a vivir?
We have aunts and uncles.
Okay, so she has some place to stay that you can provide an address to pretrial for.
Tenemos tíos y tías donde ella puede ir a vivir. Ah, bueno, entonces ella tiene un lugar donde ir a vivir, donde si la dejamos en libertad bajo los servicios especiales, le pueden dar esa dirección donde usted iría a vivir.
Okay, ma'am, do you currently work?
Señora, ¿trabaja en la actualidad?
Sí, señora.
Yes, ma'am.
Okay. All right, I am going to What type of work do you do, ma'am?
¿Qué clase de trabajo hace, señora?
Trabajo en un front desk de un salón.
I work at the front desk in a salon.
All right, I'm going to order, I do find probable cause, I'm going to order pretrial with no monetary bond and no contact with the victims.
Encuentro motivo fundado para tenerla detenida. Voy a dejarla en libertad bajo los servicios especiales de la corte. No tiene que pagar una fianza. No puede tener contacto o comunicación con la víctima.
And so that's no monetary bond in all counts.
Okay. Para todas las acusaciones, en ninguna le impone fianza, solo la dejan en libertad bajo los servicios especiales de la corte.
You'll need to provide pretrial with an address where you'll be staying that they can verify before they're going, so that they'll release.
Tiene que, entregarle una dirección a esos servicios especiales de la corte. La representante estará allá para preguntarle. Ellos la dejarán en libertad una vez que esta entidad confirme la dirección.
So you releasing her pending verification?
Yes. No. I'm going to release her pending verification. Her daughter's here, so she can assist in getting all that expedited. Okay.
Los servicios especiales pregunta a la señora.
I said pretrial.
Momento, señora.
I did say she heard pretrial.
She said pretrial, release the pretrial, but pending verification, if they can't verify the address, she got to bond out with cash.
Señora, la señora secretaria está pidiéndole a la señora juez que si no le impone una fianza y que va a dejarla en libertad bajo los servicios especiales de la corte, pero la señora de los servicios especiales de la corte dice que si es que la van a dejar en libertad, pero todavía está pendiente que confirmen su dirección. Entonces la secretaria pide que si no se va a confirmar la dirección, entonces podrían imponerle una fianza. Your Honor, the interpreter, I'm so sorry, was not able to hear.
She's released the pretrial.
Pretrial,
She's
no
released
bond.
to pretrial.
No bond.
The daughter will, with no monetary bond.
Yes, Your Honor. Señora, entonces si la dejan en libertad bajo los servicios especiales de la corte y no tiene que pagar una fianza. Gracias, señora.
Gracias.
Thank you.
Where is Miss Robinson?
Miss Robinson's in Maine, Your Honor.
Thank you. Good morning, Miss Robinson.
Good morning.
You are charged with battery on an officer, firefighter or EMT, DUI, alcohol or drug, second offense, resisting an officer without violence, driving while license suspended, second offense, failure to obey police or fire department, 6, driving wrong lane or side, and 7, failure to use due care. Mr. Hawker, you're standing, which tells me you have something to offer this court regarding probable cause. We have a signal.
Respect to count 1, battery an officer firefighter. Based on the review of the probable cause affidavit, it appears that Ms. Robinson was trying to drive through traffic and heavy going, and may have clipped the gun belt of the deputy in this case. Then I don't believe that there's sufficient showing of the intent to actually batter the law enforcement officer. I believe it was just the fact of Ms. Robinson was trying to drive through the traffic barriers and maybe having to raise the point. You'd ask this court to not find probable cause in count one.
Contact the officer was the vehicle?
Yes, she hit a detective with her car.
Based on the review, it seems like she may have grazed his gun belt, and that's what the officer in the probable cause states, that he saw something consistent with that. But, Your Honor, it seems that she was trying to get through the roadblocks. I understand there was a traffic homicide investigation, and the cause of this was that Ms. Robinson didn't stop. But I don't think that would show intent to strike the officer with the car so much as her trying to get through traffic and may have grazed the officer.
State, as to count one, I think Mr. Hawker's issue is it an actual intent? Or is it that if she, in the process of doing what she was doing, clipped him?
I mean, she hit a detective
I read that.
with her vehicle.
The statute. What's the statute?
The statute is that they intentionally caused.
She intended to drive close enough to the officer. She should have known. She should have known how close she was driving would have caused that.
My argument would be, Judge, that she was, those lanes were closed. She intentionally drove that way through the closed lanes, close enough to the detective that she should have known she could have hit him, and did in fact hit him with her car. This isn't a motion to dismiss in terms of what her intention was. We can't crack open her head to see if she intended it or not, but she did in fact strike a detective with her vehicle.
Well, I am going to find probable cause on all counts, including count one. If she's driving in that direction and sees an officer close enough to clip him, and she still proceeds in that, I'm going to find probable cause at this time. You can make your argument to the trial judge as to all the elements when you get there, but as to probable cause, I'm going to find probable cause on all counts. Now, prior state.
She has a prior enhanced DUI in 2014, Judge. So this would be her second with inside 5 years.
Okay, yeah, I did see that was her second on count two.
Yes.
And Your Honor, I spoke with her boyfriend. He stated that he's going to be posting a bond when she receives one.
Oh, okay. All right, Mr. Dessler, did you hear what pretrial had said about the boyfriend? The boyfriend has already said once we establish bond, her boyfriend will be posting that.
That's my understanding, Your Honor. So I would just want to hear what the state's recommendation is, Your Honor.
Yeah, I would too.
On count one, Judge, the state would be asking for the standard bond, well, actually, the $3,500 bond.
For count one?
On count one. Count two is the standard bond of $1,000. That's fine.
Okay. All right.
We have no objection to that, Your Honor.
Okay, then I'm going to order on count one a $3,500 bond, and on count two a $1,000 bond, and on counts 3, 4, and 5 no monetary bond. I'm also ordering no alcohol.
I understand. Thank you, Your Honor.
All right. Shaniqua Shipman.
No, Broward, Your Honor.
Thank you. Oh. All right, Ms. Shipman, you are charged with battery on an officer and resisting an officer with obstruction with violence. Mr. Hawker, you have something to add regarding probable cause.
Yes, sir. I think we've heard with regards to count one, battery of an officer.
Yes.
Review the probable cause affidavit. It states that the officer was working in approved off-duty security detail. Doesn't say whether or not he was wearing his issued police uniform. Then he states he approaches Ms. Shipman with a universal greeting, but he doesn't really give specifics as to what that universal greeting is. And then at some point,
I never touched the officer. They have cameras.
Ms. Shipman, please, let me make these arguments. Then there was some argument that there was an issue in the probable cause that she attempted to grab something from Officer Perez's hand. Your Honor, I don't believe that there's probable cause to show that at the time that she attempted to grab something or grab her ID out of Officer Perez's hand and therefore squeeze his hand, that she knew or had reason to know that Officer Perez was a law enforcement officer engaged in lawful performance of his duties. I believe that's absent in the probable cause as
Judge, the sentence right after says, I then told Shipman she was under arrest and to place her hands behind her back, and she begins resisting with violence after that.
Never touched. At that point, then she begins to place arrest. At that point, the alleged battery had already occurred. So that would have been after the counts that arise to count 1. And then she's charged with count 2, resisting without violence. That's why they make a probable cause argument as to count 2. But at the point that officer says that, the battery which is alleged in the probable cause affidavit had already occurred.
One moment, Your Honor.
I didn't touch that man.
Please remain silent, okay? Regarding the facts of the case.
I don't see anywhere where he identifies himself as an officer or has any sort of uniform on, just as the public defender said. He just says he introduces himself with his universal greeting.
Exactly.
And I agree that we don't know exactly what that is.
Okay. I find no probable cause for count 1.
Judge, I would be asking at least to find probable cause battery-wise. She still intended to strike someone, whether it be an officer or not. Just him acting, even as a security guard, is still gives rise to probable cause for a first-degree misdemeanor battery.
That's not the charge.
Didn't touch.
It's not, but you can find probable cause for a lower charge, as long as the elements are still met, which they are with a battery.
They are met for an unlawful touching of a person.
Yes, first-degree
that
battery.
is in there, and Mr. Hawker.
Touch my ID.
Okay, ma'am. Ma'am, please.
Sorry, ma'am.
Okay. Okay. I am in that I am finding probable cause to the lesser on count 1 of simple battery, not battery on a law enforcement officer.
I understand, Judge.
Okay, and on count 2, resisting of an officer. Now, as to the issue of bond.
I would be asking for a $500 bond on count 1 and a $100 bond on count 2. I don't have that she has any priors.
Okay, Mr. Hawker, do you have anything to say regarding bond?
Given the fact that it's a lesser charge now, 2 misdemeanors, she doesn't have any priors, we would ask the court to give her, release her with release on recognizance.
Ma'am, do you live?
Your Honor, she does have priors out of New Jersey, 2011 assault on law enforcement, 1990 aggravated assault, which was dismissed, and 2013 prostitution, which was
It's dismissed.
It does seem as if her permanent residence is New Jersey.
Do you have?
I have family.
Do you have family?
I have a friend that lives. I have a friend that lives in Fort Myers. I have the number and everything that I can stay in Fort Myers, not too far.
She's in Fort Myers.
She does, no, Your Honor, that's out of.
It's out of county?
Yes.
Okay. Do you have anybody in Broward County that you could stay with?
I was visiting here on business.
I understand.
At the, I don't know anyone but my friend that lives around here. That's it. I'm not from here.
So pretrial can't take her because she's out of county. She's going to be staying out of county. All right. do you presently work, ma'am?
I have my own company.
Okay.
I have my own business.
Okay. And what was your recommended bond?
It was $600 total, Judge, 500 on the battery, 100 on the resisting without violence.
Okay. Ma'am, I do find probable cause as stated on count 1 for simple battery, a lesser charge, and count 2 resisting an officer. I'm going to order $500 bond on count 1 and $100 bond on count 2. And no contact with the victim. Okay, ma'am?
Okay.
So,
thanks.
Have a good day.
Thanks.
Zakia Naomi Fletcher.
In Maine, Your Honor, she says she's retained attorney Alex Ariaza. So she's saying she has not retained Alex Ariaza. I'll represent her, Your Honor.
Okay. All right, Miss Fletcher, you've been charged with neglect of child with great bodily harm, neglect of child with great bodily harm, and 3 counts of neglect of child with great bodily harm. This was the
shelter
8-year-old
hearing.
and the 3-year-old shelter hearing.
Yes, Judge.
Okay. All right. I have reviewed the probable cause affidavit, ma'am. In fact, I just had early this morning the shelter hearing for the children. So, Mr. Hawker, you're standing. You have something to present to this court regarding probable cause.
With respect to one of the charges, I'm not sure which would go to the youngest child.
The baby?
Yes.
The 6-month-old, correct?
6-month-old, yes.
Okay.
There's 3 charges. The 6-month-old was found in the bed with Ms. Fletcher.
Unresponsive, I understand.
With no type of child protective barrier to prevent the child from rolling off the bed or preventing the defendant from possibly rolling over onto the child.
Oh,
There
the
are
child was
allegations.
sleeping in the bed with
Yes.
her,
And there are
she was
allegations.
unresponsive.
She was drinking, yes.
That was the allegations I read. She was
Yes.
unresponsive because
The defendant was unresponsive, not the baby.
I meant the
Just in case.
the
Yes.
arrestee. Yes,
The
I
arrestee.
did. I meant that.
Now, I just would argue that the baby was at home in the bed sleeping, and we would ask the court not to find probable cause as far as neglect with that, and she was sleeping in the bed with her mother.
Okay. Sir, sir, who are you? You have your hand raised.
I'm the father of the kids.
You're the children have been placed with you.
Yes.
Okay.
Can I say one thing? The baby is always in a crib, but I guess she put it in the bed. But when she do put it in the bed, it's on pillows surrounding her, so she can't roll. And she hasn't started rolling yet. She stays on her back. But we always keep a pillow when she takes her out of the crib and put her in the bed.
Well, all right. But you weren't present at the house, sir, to be able to know what.
No,
all right. Yeah.
I know this for a fact. 'Cause
Okay, sir.
Okay, Your Honor.
All right. Well, I do find probable cause for all 3 counts. You can address the nuances of the situation with the trial court as to each criteria of the elements when you get to that stage. But for this process, I am finding probable cause for all 3.
Judge, there was a 2014 cruelty to animals with a pending violation of probation. Based on the allegations in the report, as well as the cruelty to animals charges that she had previously closed out, the state would be asking for a $5,000 bond on each count with no alcohol.
All right, Mr. Dessler, so there really is, unless you're going to be posting bond for, there really isn't anything at this moment for you to say, but I want to hear from Mr. Dessler, okay? Mr. Dessler.
Your Honor,
As to bond.
Miss Fletcher lives in Pembroke Pines. She's lived there for 2.5 years. She's been in Broward County for 17 years. She works as a certified nursing assistant. She's been doing that for 7 years. She makes $2,000 a month. So a total bond of $15,000 would be out of her reach. I would ask for a total of about $2,000 on each account.
Okay. I am going to, I'm going to order 2,000 on count 1, 2,000 on count 2, and 2,000 on count 3. At this point, pending you getting before either dependency court or the trial court, that you're not going to have any contact with your children.
No contact.
Those are the
Okay.
victims right now. So
Okay.
until such time as the trial court, and either the dependency court or the trial court on the charge, the criminal court addresses that, I will leave it up to them to determine the safety of your children. And I am going to err on the side of caution where you have no contact with the children. Dad, now, since you're here, I can look you in the eye and tell you that while the children are sheltered in your care, you are not to allow Mom to have any contact with the children. Do you understand that?
No problem.
Okay, at this point in time, your loyalty is to your children. Whatever there is with Mom, your loyalty right now is to your children, to keep them safe. And until further order of a court, you will not allow her to have any contact with these children, and you will keep them safe.
No problem.
All right, I just want you to make
Thank you.
sure you understand your responsibility.
Can I tell her that the phone is on?
Pardon me?
That the phone is on? 'Cause
Does she need to be able to contact you to make those arrangements? Mr. Dessler, does she need her phone to, he says her phone's on, does she need her phone, in order for her
Yes,
phone
Your Honor.
to be able to?
She's telling me
what?
now that she
Oh,
needs her phone.
Okay, wait a minute, too many people talking at one time.
That she,
numbers, yeah.
yeah, if she could please have access to her phone, Your Honor, if you could sign an order to that effect. That's what we're asking for, so she can get her phone
All
number.
right, she just needs the phone.
No,
Okay,
no, Your Honor, she knows the number. It's the 786 number. I just turned it back on.
okay.
Okay,
I am-
okay.
All right, but she needs her phone to get it, and I need
No,
to
she
do
doesn't
that.
need it. She knows the number by heart.
Okay.
Your Honor, she needs, I'm just asking for an order. She doesn't know the phone number by heart.
She doesn't know the phone number by
She does
heart.
not know the phone number by heart, so I appreciate
If he gives it to
his
her now?
insistence. Sorry?
No, you don't want the number all over the internet.
Right, yes. You can ask him to give it to Mr. Hawker, and he'll
Mr.
call us.
Hawker, if you get, sir, give it to Mr. Hawker, and then she will get that number. Okay,
Thank you, Your Honor.
thank you.
I'm gonna prepare the order.
Pardon me?
I'm still gonna prepare the order to allow her to access.
Right, well, she'll need that. That's why I said I did enter the order to access her phone, and then you'll have, okay, Janice Casada.
President Maine, Your Honor.
All right. Ms. Casada, you are charged with resisting officer obstruction with violence, reckless driving, first offense, failure to use due care, disobeying, avoid traffic device, and driving through a safety zone. Are you half up, half down, Mr. Hawker? Not quite sure. I do realize.
Are you probably called?
Okay.
This is a charge of resisting an officer with violence. The probable cause affidavit states that there were a number of attempts from Ms. Casada to avoid being placed into custody, but nowhere in the probable cause affidavit does it say that she offered violence. There was stated there had to be force used against her to get her into the car, but there's no mention of Ms. Casada using force or violent or threat of violence to resist officers. We would ask this court to not find probable cause of resisting an officer with violence.
State.
It does say, Your Honor, the probable cause that she made an effort to get away from me by trying to get up in an aggressive manner. She made a conscious attempt to resist my actions by tensing her arms in front of her. Once inside the car, she kicked my body-worn camera off my chest.
All right, I do find probable cause on all counts. State as to priors and bond.
She has a 2011 battery in Miami-Dade County. The state would be asking for a $5,000 bond on count 1, and the others are traffic tickets mostly.
Mr. Dessler, as to bond.
Your Honor, Miss Casado lives in Coral Springs. She has family down here. Her ex-mother-in-law lives down here. She has a 9-year-old son. She works as an intake specialist at a mortgage agency. She makes about $2,000 a month. I'm asking for a $1,000 bond to be imposed on count 1, Your Honor.
Okay. All right. I am going to order $1,000 on count 1. What was your recommendation on count 2?
Count 2 is a traffic ticket, essentially, Judge. It is criminal, but it is...
All right. Well, I'm going to order $1,000 on count 1, and
There were allegations that she was drinking. If we could order no alcohol as well.
that's what I thought I had read. All right, and no alcohol.
Thank you, Your Honor. Also, Your Honor, if I could request an order that my office could take photographs of Miss Casado's injuries.
Yeah, I was just about to ask you. Thank you.
Okay, I'm so ordered for photos. I like that little tandem. Okay, Michelle Lee Vaughn.
No problem, John.
Okay, Ms. Vaughn, you
Yes,
are
ma'am.
charged with grand theft over 500, under 5,000, and a violation of probation or community control as to your other felony count.
Can I say something, Your Honor?
Were you here this morning to listen to my original colloquy of not to state any facts of your case because you have a right to remain silent? Anything you say can and will be used against you. This is only to determine probable cause and possible pretrial release if it's appropriate. Any questions or any statements should only be directed to the issue of bond or release, ma'am. Is that what you wanted to talk to me about?
Yeah.
Or about the allegations and the facts of the case?
No, ma'am. The only reason what happened was
No,
because my
ma'am.
dad.
See, ma'am, please. If you want to start talking about what happened, that's about the facts of the case. That would not be what you want to do because it's all being recorded. Okay, so as to grand theft and as to the violation, I am finding probable cause. State?
She's already being held no bond on count 2, Judge. On count 1, just so Your Honor knows, she has a 2016 possession of cocaine and many municipal ordinance cases. She's currently on probation for that 2017 case.
Okay. Mr. Hawker?
She'd be held on non-monetary conditions on count 1. She's already being held no bond on the probation violation charge.
All right. Is she working? Are you working, ma'am?
Yes, ma'am.
All right. I am going to order a $500 bond on count 1. But ma'am, just so you're aware, count 2, which is essentially your violation, is no bond right now because you have to go before your trial judge on that. You have a hearing on May 9th at 8:45, so you won't be released today. You'll need to address the violation issue with the no bond with the trial judge. I don't have any authority to supersede that. Whatever you address with that, I am ordering the bond on count 1 on the grand theft of $500. Okay?
Okay, thank you.
All right, have a good day. Sarah Marie May.
President Maine, Your Honor.
All right, Miss May, you are charged with robbery with a firearm. Is that what that's?
Yes, Judge.
And 3 felony capiouses.
Judge, this is the packet that I gave you beforehand with the affidavit to arrest.
Yeah, it is right. Well, you should be coming back to jail after this.
Oh, that's right. Did somebody else try and talk to me? All right. He's holding down the button like, are you waiting for me to say something, Mr. Dessler?
No, there's crosstalk.
I was wondering whether somebody was trying to talk to me.
there's crosstalk.
All right. I do have the affidavits for arrest on the capiouses, so I do find probable cause. I've read the probable cause affidavit, so finding probable cause on all counts. State.
Yes, Judge, this is a punishable by life felony, so I'm asking if you have found proof evident, presumption great, to hold the defendant no bond based on the affidavit to arrest that I provided.
All right. I've read the arrest affidavit, Mr. Dessler. Do you have anything to add?
Your Honor, unfortunately, in Maine, we don't have the arrest affidavit. I would ask if Mr. Hawker's had the time to review it. I can't make any objections to the arrest affidavit.
Mr. Hawker, have you read what I've read?
I've read it. I have no objections at this point.
I thought not. All right, I do find proof evident presumption high based on the affidavit of arrest and the allegations raised in there. So I am ordering no bond at this time.
Your Honor, if I could request an order that Miss May can access her property so she can get her phone to get the phone numbers for
kids.
Sorry?
What kids?
So she could talk to her children. Just so she gets the phone number.
Okay. Okay, I'm going to grant the request for a photo order as well as access to property to let her family know where she is and what's going on.
Thank you, Your Honor.
And that's my mistake. I wrote that down wrong. It's just a phone order we need.
Oh, all right. You guys should coordinate better.
No, that's the photo he does. I just wrote down the wrong word, photo phone.
Okay, so just in order for access for her phone, Mr. Hawker
Yes, Your Honor.
misspoke. All right.
Thank you.
Gabriella Kaylin DePass.
Bonded, Your Honor.
Oh, okay. Alicia Marie Bowerson.
No problem.
All right, Miss Bowerson.
Yes.
You are charged with possession of heroin.
Yes, and the charge
Ma'am.
I'm sorry, yeah.
Okay, the public defender is here to represent on your behalf. He might want to say something to you. Mr. Hawker, do you want to just remind her? Not to.
I'll be advocating on your behalf, okay?
He's saying don't say anything, okay, until somebody asks you specific questions.
Okay.
All right. Mr. Hawker.
Matter, reviewing the probable cause affidavit, there doesn't appear to be any evidence that, she was in possession of cocaine. I mean, you're saying something about detox, but possession of heroin. There wasn't any substance found or recovered. There wasn't any substance tested. We asked this court not find probable cause on possession of heroin.
Judge, there's a capias out for the possession of heroin. It was a not in custody capias. There's another probable cause affidavit. I don't know if Your Honor or the public defender has this one. This is from December 7th of 2016. I believe she was just picked up on the capias with the one that you're speaking about, May 6, 2017. Is that?
I didn't have the other probable cause.
Okay, I can provide if I need to. There's a capias from Judge Colra. The possession of heroin charge, $1,000 bond. It was a not in custody capias that was issued by him on April 18th, 2017. I have a not in custody probable cause affidavit as well, if Your Honor or public defender needs to see either of these.
Okay. I have the 2017 capias that was issued on 4/18/2017 on case number 17-4001.
Yes, Judge.
Okay, but here's the question I have. This was not, what I'm looking at is for possession of heroin, not a capias for possession of heroin.
She had a capias for possession of heroin at the time that I believe the allegations are her mother calls the police that she's threatening. There's another probable cause affidavit, which I have, which I just showed the public defender, in which the not in custody capias that Your Honor has for the $1,000 bond is issued upon. Basically, I believe it was December 2016, there was a probable cause affidavit done, not in custody, once the state probably filed the charges, which was that April 18th, 2017 date. I can show Your Honor as well.
No, I have it. I've read it. I'm looking at what's attached. I have the affidavit.
The capias.
I have the capias. I have the probable cause affidavit on the capias. Here's my question, okay, for clarification. And the public defender has aptly pointed out my perplexion on the same issue, which is on count 1, it doesn't say capias for possession. It doesn't say prior capias or anything. It says, and it references, hang on just a second.
I think it references that case number.
Okay, hang on just
the warrant capias.
All right. So its intention is then that the possession of heroin is the count is for the capias on the possession of heroin because it's referencing the case number.
Yes, Judge.
I think, Mr. Hawker, what happened is they just didn't appropriately put on there what exactly was the issue, but it references the case that it reflects the issue of, which is the capias. On that, I do find probable cause. You're correct, when they went and picked her up, that was not a new charge. That is still dealing with the prior charge, so that the record's all clear. What I'm finding probable cause on is the execution of the warrant for capias from the 2017 4001 case. Okay, so we're all clear? Mr. Hawker, do you have any further objection on that? Okay, so on that respect, is that it's a bond of $1,000. Ma'am, you were already, there's already a bond set by your trial judge on your prior charge pending before Judge Cholera. I have no authority to interfere with that, so that bond still stands, all right? So.
Okay.
All right, have a good day.
Thank you.
Paris Ashley Washington.
President Maine, Your Honor.
Miss Washington, you are charged with failure to disclose facts for public benefits, I assume?
Yes, public aid over $200.
Public aid over pardon me? Oh, good news, your bond's been posted, so I just need to address the issue of probable cause. And based on the affidavit, I do find probable cause Your bond of $1,000, I guess, is that what has been posted? So, have a good day, ma'am.
Thank you, Your Honor.
She wasn't as happy as Guy yesterday. Remember Guy? Oh, you weren't here yesterday. But Mr. Hawk, you remember? Yes, he was doing the Heston dance. He just was like, oh well. Okay. All right, Brandy, Deanne Gaston.
Yes, ma'am.
She should be in. Okay.
Where is
And
she?
North Broward.
Thank you.
North Broward.
No Broward, Your
All
Honor.
right. Okay, good morning, Miss Gaston.
Good morning.
Okay, you were picked up on a violation of probation.
Yeah, I want to do a drug program and
Okay,
just
ma'am.
not do the probation.
Okay, well, ma'am, that is not what this court has the authority to deal with, okay? So at this time, because of the violation, you need to go before the trial judge, address the issues then on how you want to address the violation and what you want to do and what they want to do. So, they've set a bond for the violation of $7,500, and this court has no authority to interfere with that. You have a hearing on that on May 8th at 9 a.m. Your trial judge will address it at that time. Do you have anything further to add, State?
No, Judge.
All right, thank you.
Thank you.
Andrew Michael Weingartner. Oh, okay, fine. All right, so I find probable cause because the KPS and he bonded. All right. Barry Anthony Robinson. Mr. Robinson? Jr.?
Yes, Your Honor, in Maine.
Oh, okay. Mr. Robinson, you have been picked up for a capias on your misdemeanor. And that is a no bond based on what I'm seeing.
Yes, Judge.
So, this court has no authority. I find probable cause because of the capias. You have a status on that on May 9th at 1:30. This court has no authority to adjust that no bond status. You'll take that up with your trial judge. Have a good day.
Thank you, Your Honor.
Efren Rodriguez.
President Maine.
Okay, Mr. Rodriguez, you're charged with driving while license suspended. Your first offense. Mr. Hockner, you're standing, so you have an issue with probable cause. You may.
Yes, Judge. Looking at the probable cause affidavit, it doesn't really say anywhere where like he currently has a driver's license suspended. It says he had 5 prior convictions. NCIC check stated that there was a current suspension for driving while licensed.
No, do defendant name.
He didn't say,
Rodriguez.
They say as a result he was operating motor vehicle without a valid driver's license.
Oh, no, you're not taking it.
NCIC check that showed that his license was currently suspended. You would have to report that by probable cause.
State.
If you'll give me one moment, Your Honor.
Okay.
The PR. Double click. Go to case. Book. DL request. Put submit. It doesn't show that he ever presents a driver's license, period. It says he's stumbling through his wallet when asked to present a driver's license, and they ultimately find that he's operating the motor vehicle without a valid driver's license because he hasn't even presented one.
Well, here's the nuance, Miss
Gomez.
The public, Mr. Harker, very aptly, has pointed out the distinction of statutes on driving without a license as opposed to driving under a suspended license.
I understand.
So what I will do is give the state 48 hours to perfect the
It's not his date of birth, anyways.
charge
Mhm.
and determined whether or not it was suspended or he just had no valid.
Okay. Either
And-
which way, it would be a misdemeanor. Would you find probable cause for driving a motor vehicle without a valid license?
Yes.
Okay.
I mean, which would be the lesser of. He did not, Mr. Hawker, provide any proof of license at the time. So, at the very least, he was driving without a valid license,
Actually, no,
which is a misdemeanor. So I am finding probable cause for the lesser at the very least, but the state has 48 hours to perfect their driving while license suspended, and I'm ordering a $100 bond on count one. Okay? Anything further, Mr. Dessler?
Your Honor, Mr. Rodriguez lives in Miami Gardens. He's lived there for 5 years. He has a wife and 2 children, ages 13 and 14. He works as a handyman. He's been doing that for 25 years. He tells me he has no access to his wallet, that it was actually left in the car, and his phone's in the car as well. And so he's unable to contact his wife, and he's unable to post the bond himself because the wallet's in the car, not here at the jail. So I would ask for him to be released on non-monetary conditions.
Okay. All right. Then let me amend. I'm going to release him on ROR.
Okay.
Your Honor, God bless you.
As long as we're finding PC for something to give a bond on, then I won't need 48 hours.
Fine, then we won't need to perfect because I found on the lesson. All right, Melvin Lloyd Delancey.
North Brown, John.
You're good.
North Brown? Mr. Dessler's a hero.
Yes.
Mr. Delancey, you were picked up on a capias on a prior misdemeanor charge, and that was set at a bond of $100 by your trial judge. I do not have the authority to disrupt that, so you will be addressing that. Does he have a follow-up hearing on his capias?
I don't have anything written on the docket,
Neither
Judge.
do I. Does anybody know? On his case, Mr. Delancey.
Delancey?
I understand
Melvin.
that. Does he have a follow-up hearing on his capias?
No, because it's from the satellite.
It's from the
Melvin.
satellite. All right, Mr. Delancey. You'll have, the satellite will be getting in contact to be able to let you know when you need to go before the judge on that. But right now, your bond from that judge on that capias is $100.
I was sleeping in the street.
Pardon me?
I was sleeping in the street. I was sleeping in the street. I wasn't.
Okay, sir, this is
I
not.
was sleeping in the street.
Sir, this is not the time to discuss the facts of that case. You're only
No.
before this court on the facts.
It is what it is.
Okay, sir.
What you saying?
Sir, no, sir. Mr. Hawker, do you want to address anything with?
Yeah. Last night.
Sir.
Last night.
Listen to your attorney. You were arrested on the cases. The time is not now to address that, okay, sir?
It wasn't me.
Mr. Delaney.
KP, what? What's KP? What are you talking about?
Said KP.
KP, that ain't me. Who the fuck is that?
Listen to
This bullshit. Fuck out of here. Take this shit? What the fuck you doing with this motherfucker? Fuck out of here. Fucking dummy.
Who's he before right now?
Say real, man. It's bullshit.
Okay, so I can transfer the case.
He can be used against you. Okay? Everything you say is being recorded right now.
Okay, all right. How soon can you get before that court? Okay, great. What I'm gonna do, Mr. Delancey, and Mr. Hawker, I'm gonna transfer this case to mental health court, which will get him before the court by next week. Okay, Mr. Delancey? I'm gonna transfer your case to mental health court, and they will address the issue at that time. right, right
Yeah,
now.
take your mental health too.
Your Honor, we can have an order signed that Mr. Delancey can be evaluated if necessary.
I believe that's something to do in the division courts because that's how they decide which
Yeah, I don't
doctors.
have that kind of authority.
I'm sorry, when I mean evaluated, I don't mean by a competent doctor, but just evaluated by a mental health professional at the jail, someone who can provide him any necessary treatment or medications if necessary.
Oh,
While
for the
he's in the
short term.
jail, that would be okay.
Yes, I'll enter that order for the short term until it gets before the trial judge, just in case there's some immediate needs to be addressed for mental health. Okay. All right. Omar Walker.
President Maine, Your Honor.
All right. Mr. Walker, you were picked up on a KPS on a traffic violation. And that has already, your trial court judge issued the KPS has already set that bond at $500. I don't have the authority to interfere with that. You have a status on that case on May 17th at 9 a.m. All right, so my work is done.
I ain't got no.
My work is done. Thank you. Have a good day.
Thank you, Your Honor.
Delmas Keith Knight.
President, Your Honor, this is a municipal ordinance. I cannot represent him.
Okay.
Christopher Hill.
All right, Mr. Knight.
You have a lawyer? Are you own attorney or do you want to? You're not sure.
Okay, state, since this is a municipal ordinance, you don't have anything to do with it.
I don't, Judge.
And I know it's Sunday, so the attorney for the county.
There is a standard bond set at $25, Your Honor.
Hey, yo,
All right, Mr. Knight.
You gonna be able to make it though?
Yeah, no,
All right, Mr. Knight, I've read the probable cause affidavit.
Man, they would let me go, man. I already mind myself up.
No, when you get up there, they're gonna tell them like they just told the other person. If it's not, they're gonna read you the ordinance.
I can put up for you.
And then,
Yeah, my issue is
they're gonna go through it.
I've got some concerns. If, I believe the ordinance may be as to how much interference or stuff. I don't know if it's technically just the fact that just one side.
We're trying to look it up. I don't know if we'll be able to find it, but it's Fort Lauderdale Municipal Ordinance.
Yeah. All right, well, if I don't find it,
Maybe like Fort Lauderdale.
Okay. All right, Mr. Knight. After reviewing the probable cause affidavit, I don't find probable cause. So I'm dismissing this charge. They'll process you out, sir. Case concluded. Thank you. Have a good day. Willie James Lawrence.
No crowd, Your Honor.
Thank you.
Good evening. Good evening. Good evening, Your Honor.
Good morning. Still morning. I had 15 minutes.
Oh, good morning.
You are charged with a violation of municipal ordinance. of disturbing the peace and quiet of the occupants by knocking on windows of a vehicle and soliciting money from occupants. All right.
No, ma'am.
Okay, sir. I've read
Yes,
the
ma'am.
probable cause affidavit, and I do find probable cause. The bond is $25. Do you live in Broward County, sir? Do you have a
Yes, I'm
place to live in
homeless.
Broward County?
No, ma'am. I'm homeless. I just came down. I got operation on my right eye.
You have what, sir?
I had an operation on the right eye on December the 5th.
Okay, all right. I think there's a facility right up the street, if you were released, that you could find a bed.
Yes.
Okay. Have you checked there, sir? The facility
Yes.
up the street, the homeless facility up the street from North Broward.
No. I go there and eat sometime, but
Okay. All right. Well.
I'll check.
All right. All right, sir. I do find probable cause. I'm going to release you an ROR.
Thank you.
All right. And you just need to make sure you appear for your court date, okay?
Yeah.
All right?
Yes, ma'am.
All right. Have a good day. Levanta Jamar Smalls.
President Maine, Your Honor, he's declined the services of the public defender.
That is his prerogative. All right, Mr. Smalls, you are charged with disorderly intoxication in a public place which caused a disturbance. I have read the probable cause affidavit, and I do find probable cause. State.
Judge, he has a 2017 trespass, which he was adjudicated, 2016 resisting without violence and loitering and prowling adjudication, and a 2012 loitering and prowling adjudication. We would ask that the bond be set at $100.
Mr. Smalls, do you live in Broward County?
Yeah.
Pardon me?
Yes, ma'am.
Okay, how long have you lived in Broward County?
My whole life.
All right, do you have a job?
No.
You're not working. Are you in school?
Nope. Nope. Trying to get in school.
Okay. All right. Well, I am ordering a bond of $25, sir. I also am ordering no alcohol while you're on release. Do you understand?
So you're telling me I can't drink ever again?
Well, you can't drink while you're pending these charges, sir. Yes, I am saying while your charges are pending, until somebody else tells you otherwise, you are not allowed to drink. That's the order. When you can take that up with you. Can you hear me?
Can I hear the police report? But
You want to hear the
Yeah.
probable cause affidavit read out?
Yeah. Right now.
All right, you have that right. On May 6, 2017, the officer responded to 296 South Fort Lauderdale Beach Boulevard in reference to an individual who attempted to attack a lifeguard. Upon arrival, the I is the officer, observed multiple lifeguards holding the defendant to the ground on the sand. The defendant tries to break away from the lifeguards multiple times. I, the officer, assisted the lifeguards in controlling the defendant, was able to place him into handcuffs without further incident. I then spoke with the two listed lifeguards to ascertain what had occurred. The listed lifeguards advised that they had to complete an ocean rescue due to an individual almost drowning. Upon bring this individual to the sand, the listed lifeguards advised the defendant attempted to intervene in their life-saving operation. The lifeguards advised the defendant tried to pull them away from the individual being rescued. Lifeguard
They didn't even rescue him.
Okay,
They didn't even get in the fucking water.
Sir, Did you hear my colloquy at the beginning of this morning when I advised everybody that you have the right to remain silent and that
I
anything
can
you
keep reading it. I
use,
apologize.
sir,
Can keep reading
sir,
it.
if you want to continue to talk and have whatever you say used against you in your
I'm tired
subsequent
of the
charges,
fucking lifeguard.
that is up to you.
I dragged
But
that nigga to the sand.
I have stated that you do have the right to remain silent and everything's being recorded, sir. You have declined the service of the public defender, so you don't have an attorney to tell you just how what you do right now in that microphone will affect you subsequently in other proceedings. So do you want me to finish reading this, or
Yes,
are we
please.
conclude? All right then. I attempted to speak to the defendant. The defendant had an overwhelming odor of alcohol beverage emanating from his person, an odor of marijuana emanating from his person, and bloodshot, watery eyes. I'll
2000
continue to read this, sir, but it's not pretty. The defendant was acting belligerent and began to call me a, quote, Nigger, unquote. It's a word I can't even verbalize, so I just spelled it out. When I asked what had occurred, based off of the statements made by the lifeguards in my interaction with the defendant, it was found that the defendant was so intoxicated that he endangered the safety of another person and was causing a disturbance in public place. I advised the defendant he was under arrest. The defendant was transported to BSO Main Jail, where he was direct booked. I found probable cause, sir. I am ordering a $25 bond. We are concluded no alcohol while you're
That
under
shit
this order. You can
stupid.
address it when you get before the trial judge as to any further wishes to imbibe on alcohol while you're pending for that judge. Elvis James Fleming.
President Maine, Your Honor.
Thank you. Mr. Fleming, you were picked up on a capious misdemeanor with
Trespass.
I know. Do you know who it's before?
Division MA is Judge Brown.
Okay, sir, you have a pending hearing before Judge Brown on May 11th at 10 a.m. And the bond on that capious was already set. This court has no authority to change that. You're under a $500 bond on that capious, sir. So you'll. All right.
ma'am. All
So
right.
have a
All
good
right.
day.
All right. Okay. All right. You ready? Come on, sir.
David Stiller Oaks.
Okay.
Is he
He's
somewhere?
approaching, Your Honor.
He's where?
He's approaching.
Oh, okay. All right, Mr. Oaks, you were picked up on 2 misdemeanor capious warrants under. Does he have follow-ups on those? There's no follow-up hearing. It's at the satellite. All right. Okay, those bonds were already set on those 2 warrants of $500 each, and this court has no authority to adjust that. We don't have a follow-up date because it's out of the satellite. Mr. Dessler, do you have anything to add?
Your Honor, Mr. Oaks is 64 years old. He appears to be very frail. I understand you cannot change the capious, but I'm asking if there's any way he could potentially resolve the case today. I'm not sure he would do well in custody, especially if he doesn't have a future date. It could be some time before he gets in front of a judge.
That's my concern. State, can you tell me what's going on as far as priors and status of anything else pending and what it is exactly that is, I'm looking at trespass. I'm looking at 2 trespass.
Yes, Judge. We'll have to look up the priors because we have not looked them up since he was being held on those capiouses. If you'll give me.
It does appear that there could be some health issues that. Okay, Mr. Dessler, how about if we put this
Yeah.
on recall while they look that up?
We have them up now.
Hold
Sorry,
on,
we just
have
needed
them
a few
up. Wait a minute,
seconds.
they just, yes, it's the wonky Wi-Fi in the building. I live
It's
with it
fine, Your Honor.
daily.
There's a 2016 trespass adjudication, 2014 trespass adjudication withheld, 2014 petty theft adjudication, 2014 felony petty theft, which was dropped, 2012 petty theft adjudicated guilty, some county ordinances, a 2010 disorderly conduct adjudicated guilty, 2010 disorderly conduct adjudicated guilty, 2008 theft adjudicated guilty, municipal ordinance, trespass, adjudicated guilty, that was 2008. Traffic. And that's it.
Okay, Mr. Dessler,
Yes, Your Honor.
and state you have any.
I would object to closing out the case now. I understand the situation that Mr. Oakes is in. However, those KPSs were set by the division judge, and I think he should need to go in front of a division judge to close them out.
But you don't have a date when that would happen?
I don't, because whenever they're at Satellite does not take in custody defendants. They're only out of custody defendants. So once somebody's taken into custody, the case should bounce to a division here at Central.
Your Honor, if I just may add, Mr. Oakes tells me the reason he missed court is he was in the hospital. He has a fractured kneecap based on what he's reporting to me, and that he has upcoming doctor's appointments. And so he's interested in resolving his case.
State, I mean, I'm just asking, as far as, what's pending are trespass cases, correct?
Yes, 2 trespass cases.
Okay. I understand the protocol, State, it's just that in this situation, I'm inclined to let these be resolved. And, okay, Mr. Dassler?
Yes, Your Honor.
I'm willing to hear to resolve these today.
Yes, Your Honor. If we can give Mr. Oakes time served in court costs, Mr. Oakes would be interested in resolving the cases.
Okay, Mr. Oakes, do you understand that you have the right to have your charges fully heard by the trial judge? And if you want to, and I'm understanding that you want to resolve your charges of the 2 trespass charges today, correct?
Correct.
And by doing that, you're waiving your right to a hearing or a trial before the judge?
Yes.
And that's what you want to do today?
Yes.
Okay, and you've spoken with Mr. Dessler and been able to get advice and as to what the charges are and what your options are.
That you've spoken to me.
You've spoken to the man standing next to you.
Yes.
Very competent attorney. And
Okay.
so you've understood your rights, and you wish to waive the right to have your trial judge hear the case, and you want to settle that today.
Yes.
And plead guilty to the 2 trespass charges and resolve the issue.
That's your answer.
Yes.
All right.
Your Honor.
All right. I accept your plea of not guilty to the 2 trespass charges in case number 17778MM20A and case number 17-715MM20A, and I adjudicate you guilty and then give you time credit for time served. So you should be released today.
Judge, please
His-
going to adjudicate him guilty, because you made a mistake and said not guilty. So I just want to clarify.
Did I really say that?
Yes, that's why I just.
Okay.
Yeah.
All right,
Yeah.
so you plead no contest, sir, and I adjudicate you guilty of trespassing the 2 counts that I have said. Okay?
Thank you, Your
And
Honor.
credit for time served, so you are out.
Are we applying court costs, and how long are you giving me?
Mr. Dessler, does he have a job?
Sorry, Your Honor.
Does he have a job?
Do you have a job?
No, I'm
He's
retired.
disabled, Your Honor.
He's just saying.
I have a fractured kneecap and a bad back, and
Waive court costs, or I get a meal bid? Okay, I'm gonna waive court costs.
Thank you, Your Honor.
Randall Carson Warner.
President Maine, Your Honor.
All right. Mr. Warner.
Oh, concurrent?
No, I mean concurrent because it's two different things.
Oh.
So I just.
On both. Whatever I did on both. Mr. Warner, you're charged with touch or strike battery. I've read the probable cause affidavit, and I do find probable cause. State. What is your position? What is the prior and position on bond?
Only prior is a 2016 trespass, which was a withhold. The bond amount is set right now at $1,000. The state is fine with that amount.
Mr. Dessler.
Your Honor, Mr. Warner lives in South Miami. He's lived there for 1.5 years. He works construction. He's had that job as long as he's been down in South Florida, so he's had that job for 1.5 years. He makes $18 an hour. The difficulty for Mr. Warner is he does not have his phone or his wallet present in the jails. I'm asking for him to be released on non-monetary conditions. He does have a good address, but he has no way of contacting anybody or self-posting bond.
Okay. I'm going to. But he does have an address where he's staying that he can provide to pretrial, right?
Yes, Your Honor.
Okay. So I'm gonna order pretrial release. Is he working? Oh yeah, you did say he's working.
He works construction, Your Honor.
Okay, I'm going to order pretrial release. And give him an order with access. Where's he going? With access to his phone. And I'm going to order.
The phone's not here, Your Honor. That was the difficulty, that his wallet and his phone are not. The problem is he can't post any bond because it's not present at the jail. He doesn't have it here.
Okay, great.
That's
all
the
right.
difficulty.
I get it. Okay. Okay, I'm going to order pretrial and no monetary bond and no contact with the victim.
Thank you, Your Honor.
Thank you. Daniel Thomas Zender.
President Maine, Your Honor.
Okay, Mr. Zender, you're charged with disorderly intoxication in a public place which caused a disturbance and resisting officer with obstruction without violence. Mr. Hawker, you have something to add regarding PC.
Respect to count one, it says that, the allegations of probable cause affidavit are that, such individuals on occasion that a female waves her hand telling to leave. And I don't think that rises to the level of endangering, the safety of the persons that are on what looks like the Hollywood Raw Wall. But that's important, not find probable cause as far as disorderly conduct.
You mean causing a disturbance?
Yes, he was causing a disturbance as to touching random people on the boardwalk.
I think he walked out.
Can you pull up the statute?
By doing that, causing violence to anyone or violence or threatening to damage any property. Based on statute 85610.
The statute, okay, state, the statute specifically say it has to cause?
Endanger the safety of another person or property is what the statute states. I mean, if he's going up touching random people when they don't want him touching them, he's endangering their safety.
It may be irritating to annoy the unwanted, but I don't think that going up to people and touching them is endangering safety.
I think we'd have to ask those people.
Well, here's the thing. Did they want to be touched?
Considering one of them waved her hand and told him to leave, I would say no.
We got it, that female, it doesn't state whether that female was touched. The probable cause that they was one who was actually touched, spoke to the officer.
Thank you.
That's the point. 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 That's the point.
Yeah.
And I think touching without words of violence, without anything more, would be endangering the safety.
It's a battery, technically.
Well, here's the question though, Ms. Gomez, as to battery on whom?
I mean, he's not charged with battery.
I understand, but even so, who was he touching?
It says that he's stumbling up to people and touching them on the boardwalk.
I understand, but then we don't know if the female, as Mr. Hawker saying, we don't know whether the female waving
Was
him
touched.
off was one of the alleged victims of the touching.
And I'm not asking you to find probable cause on battery. He's not charged with
I
that.
understand that, but if the statute is requiring endangering, that's the question that Mr. Hawker is aptly raising.
I think touching random people on a boardwalk, those people could very well consider their safety to be endangered.
Okay, well, here's the thing, Mr. Hawker. I'm going to find probable cause. At this point, you can argue the nuances of the statute to the trial court as to meeting the elements, but for the purposes of this hearing, for first appearance, I am finding probable cause on count 1 and count 2. State as to priors and bond.
He has just municipal ordinance cases as priors, Judge. We would ask for a $100 bond on count 1 and the $100 bond that's already been set on count 2.
Mr. Dessler.
Your Honor, I would like to first ask for a photo order for Mr. Zender's injuries, which are on his face. I believe Your Honor could probably see them.
So
They were
ordered.
described in the probable cause affidavit. Apparently it happened during the apprehension. Mr. Zender lives in Hollywood. He's lived there for 1.5 years. He's disabled, so he does not work. He collects disability. I'm asking for him to be released on non-monetary conditions.
Okay. All right. I'm going to. Pretrial, can I send him to you?
At your discretion, Your Honor. Does he have to stay living?
I believe it's 2020 Scott Street.
Okay, Mr.
Shelter.
Dessler, does he have a stable living address that pretrial could verify?
Yes, ma'am.
Yes, Your Honor.
Okay, what I'm going to order is pretrial with no monetary bond and no alcohol.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Christopher Manu Gonzalez.
So what?
You're gonna get out. You're gonna check in here tomorrow.
Oh, I gotta come here.
No, it's across the street. Bonded, Your Honor.
Thank you. Walton February.
Present, Your Honor.
Okay, Mr. February, were picked up on a misdemeanor capias to be set in Division MD. All right. That capias has a bond of $500 from the trial judge, so I don't have the authority to disrupt
I
that.
already bonded up.
Is this here, it says to be set before Division D.
I
Is that a
believe
satellite?
yes, no, MD, maybe Judge Solomon.
Okay.
So the status just needs to be set there.
Is it gonna be set soon?
That would be the clerk.
All right. Mr. Dessler?
Thank you, Your Honor.
Okay, so, all right, so this, I mean, like I said, the bond is already established by, I think it's Judge Solomon, you said?
I believe that one was Judge Solomon, MD.
So I don't have the authority to adjust that, and it needs to be set with her division directly.
The only thing I would ask, Your Honor, is Mr. February's telling me that he just recently bonded out on this, and on the PC itself, and then on the PC itself, it says that the check revealed a possible local warrant. I don't know if it's maybe possible he bonded out, and he bonded out,
That
and
they
then he got picked
crossed,
up
that
before
communication crossed.
they removed it. I don't have access to the computers here, and I
Oh,
can't
we
check
have all
that.
kinds of computers here. Can
I don't know if someone
somebody
could check to see.
It says the warrant was confirmed on page number 2 of the probable cause affidavit.
Okay, on page 2 of the affidavit, it says the warrant was confirmed, and that was on, what date? On 5/6/2017 at 19:54, when he was arrested, they're saying the warrant was confirmed. When does he allege he bonded out?
There is
Bonded.
It's a no-show capias, so it may have been a status that was in the judge's division he did not show up to. So he could have originally bonded out whenever he was arrested, but then issued another capias whenever he didn't show up.
Do you understand the new? I think he may be
I
getting
understand.
confused with the original bonding and then the setting it for a hearing that he failed to appear in.
I understand.
You'll, Mr. Dessler, explain those legal nuances
I will.
to him. But right now,
Yes.
I can't interfere that the trial judge will set it to address this capias. Troyvon LeBron Smith.
Present, Your Honor.
Okay. Mr. Smith, you were picked up on a misdemeanor capias with, right now, your trial judge has set that bond at $2,500. You have a status hearing on this on May 11th at 10 a.m. You can address that bond and all your issues with the trial judge. This court has no authority to adjust that bond. And State, you have anything further to add?
No, Judge.
Mr. Dessler, is there something you want to tell me?
I understand, Your Honor. Thank you.
Thank you. Jermaine Finch.
Bonded, Your Honor.
All right. Michael Love.
Present, Your Honor.
Okay, Mr. Love, you've been charged with trespass property which was not a structure or conveyance. All right. I've read the probable cause affidavit and I find probable cause. State, do you have a position on bond and priors?
Yes, Judge. He has a 2016 disorderly conduct adjudication, 2015 aggravated assault adjudication with a deadly weapon, I apologize, 2011 fraudulently obtaining a driver's license adjudication, 2010 grand theft adjudication, and a 2008 dealing in stolen property adjudication. The bond right now is set at $25. The state would be asking that to be raised to $500 based on the felony priors.
From when? How long ago?
They were
Like 2008?
2016, 15, 11, 10, and 8.
Mr. Dessler.
Your Honor, Mr. Love is interested in resolving this case today, if you would entertain that, Your Honor.
Judge, technically there's a victim in this case and the property owner that he's been trespassed from. They should have a say in what the offer is.
What is that, Victor?
Mr. Dessler, did you hear what the state's position is?
I heard the state's position. Your Honor could always order him to not return. I mean, it's a trespass case. It's not like we don't need to figure out any restitution or anything. Your Honor could order him just not to return to that scene or to that victim. And if he does, there's a remedy under that situation. So from my understanding, it was...
Mr. Dessler, Promenade
Yes,
is
Your
a
Honor.
pretty big place in Coconut Creek.
Your Honor, if you order him to stay away from the promenade at Coconut Creek, he says he'll never return there.
Because it says there were multiple establishments. All right.
They denied me.
Okay, state. I mean, the reality of all these owners of establishments coming in, I didn't read anywhere where there's damages that they would have anything as quote-unquote victims. I'm just curious.
I mean, based on the felony priors, Judge, I think he should get more than just a withholder and adjudication and credit time served. He may need to look at some sort of probation offer, some sort of jail offer, and I don't know if Your Honor wants to oppose those.
Were the felonies related to this type of behavior?
They were grand theft, stealing and stolen property, aggravated assault with a deadly weapon, disorderly conduct. Some of those are...
Disorderly conduct?
No, that was a misdemeanor, disorderly conduct, but dealing in stolen property, grand theft, aggravated assault with a deadly weapon are all felonies.
And they were all recent?
They were 2015, 2010, 2008.
The 15, which one was that?
That was the aggravated assault with a deadly weapon.
All right. All right. The situation right now, Mr. Dessler, is based on the priors, the state, and aptly so, is saying that Mr. Love may have some issues to address that the trial court may want to get into as to if there's going to be a plea and a probation as to how to handle that. So I'm going to let the trial judge deal with this. I'm finding probable cause. The bond is $25. I'm gonna leave it at $25, and at that point in time, he's gonna need to, was alcohol involved in this?
I cannot remember, Your Honor.
Looking here.
I mean, he
to
was
see.
acting aggressive, screaming at patrons and bar staff,
Hang on.
causing a disturbance.
I hear you, I just wanted to see.
There's no mention of alcohol. His
No, there
behavior
isn't.
is
All right.
consistent.
All right, well, I'm finding PC, I'm ordering the $25 bond, and he needs to show up to the trial judge and plead his case then as to what he wants to do with the charge, okay?
Thank you, Your Honor.
Have a good day. Oh, yeah, all right. Ma'am, you have a...
Thank you.
All right.
Your Honor, may the interpreter make an announcement as to whether there are more defendants who require a Spanish interpreter?
Yes.
The interpreter is not allowed to stay in the courtroom past 12:30. That's
Oh, okay, that's why yesterday we didn't have this issue. Sorry about that.
Yes, Your Honor. Thank you. ¿Hay alguien más que necesite que se le interprete su caso en español? Levante la mano, por favor.
No, Your Honor. None.
And the other
Oh, not in Maine.
jails.
And at Maine, do we have sound on all the others? Mr. Soundman back there, do we have sound on all? Okay. I don't know how else to do it.
There are a few
Nobody else
names.
has said anything, so.
¿Alguien más necesita que se le interprete su caso en español en las otras salas, en las otras cárceles?
Deputy? I just want, in North Broward, did you hear the Spanish interpreter's announcement? Does anybody need an interpreter in North Broward? Okay. In Conti, does anybody need a Spanish interpreter in Conti?
No, we're good.
Okay.
No, not in North Brown.
And Paul Ryan, okay, I guess not.
Thank you.
All right. Paul Ryan was up. I don't think they need anybody. All right. John Elliott Smith.
President Maine, Your Honor.
All right, Mr. Smith, you were picked up on 2 capious warrants for traffic violation. And those bonds have already been set by your trial judge at $500 for the capias in case number 17461 TC40A, and $250 on the traffic capias for 17-15669 TC40. I have no authority to adjust those bond amounts, sir. Okay? So you'll
Thank you, Your
adjust
Honor.
those with when you have your hearing before the trial judge. I don't have one set here. I assume they'll let you know.
Thank you.
Thank you. Martin McCauley Orr.
Present, Your Honor.
Okay, Mr. Orr, you've been charged with disorderly conduct, a brawl fight, corrupting public moral decency?
Disorderly conduct.
Disorderly conduct, okay. And resisting officer with violence. I've read the probable cause affidavit. I do find probable cause. Madam State.
I don't have any priors, Judge. I would be asking for count 2, the more serious charge, for a $1,000 bond, third-degree felony.
Your Honor, he has a 97 loitering, 2001 battery, conviction withheld, 2001 stalking, 2001 violation of domestic injunction conviction, 2002 battery conviction, 2009 battery, which was dropped, 2014 DUI, 2 counts, no disposition was found, and 2016 violation of probation in the prior room.
Mr. Dessler on the issue of bond.
Your Honor, if I heard correctly, the state's not asking for a bond on count 1, and on count 2 they asked for $1,000. If that's the case, I have no objection to that. The only thing I would ask for is a photo order to take pictures of Mr. Orr's injuries, Your Honor.
So ordered on that. I am finding probable cause on both counts. I am ordering a $500 bond on count 1 and a $1,000 bond on count 2.
Thank you, Your Honor.
Stephen Terrence Matar, or Mateer. And you got the order for photos. Okay, but you heard though, right? Okay.
It's a private lawyer, I think.
Okay, Mr. Matar. You
Present,
are
Your Honor.
charged with, is it Matar or Matar?
Mateer.
Mateer. Okay.
Mateer.
You are charged with disorderly conduct, with resisting officer without violence, and also a violation of probation on felony felony count. So, I am finding probable cause on counts 1 and 2, and of course the violation being another probable cause for arrest. Because I am, okay, Madam State, the priors, other than what's pending already?
It's just the 2016 case for which he has the probation violation as a prior.
What is the charge on that?
It's the robbery by sudden snatching.
Okay, all right. He does have a follow-up. That one, because it's a violation, I don't have the authority to order a bond on that one. You, Mr. Mateer, you do have a status, a hearing scheduled already for May 9th at 8:30 in the morning before your trial judge. So I am going to, I'm not ordering a okay. Mr. Dessler, do you have anything to say regarding the others?
No, Your Honor, we're fine with the convenience bond on count 2, and then count 3 he'll be held until he sees his judge on Tuesday.
All right, so I'm not ordering monetary bond on count 1. I am ordering a bond of $100 on count 2, and the KPS stands for no bond, and you'll deal with the trial judge.
Thank you, Your Honor.
All right. Christopher Paul Hill.
President Maine, Your Honor.
All right. Mr. Hill, you've been charged with possession of cocaine and possession of cannabis, 20 grams or less. I've read the probable cause affidavit, and I do find probable cause. Ms. Gomez.
Yes, there is a 2008 possession of cannabis adjudication, 2006 resisting without violence adjudication, 2006 trespass, 2004 possession of alprazolam, diazepam, amphetamine, and cannabis adjudications. The state would be seeking the $1,000 bond that's been set on count 1.
Mr. Dessler, as to bond.
Your Honor, Mr. Hill is unable to post the bond himself. I would ask for him to be released on non-monetary conditions. In the alternative, if you're going to hold him on a monetary bond, I'm asking for an order for him to access his phone in property just so he can call family and friends for them to assist in him posting bond.
Does he have a job?
Yes, I do have a job. Yes, Your Honor.
Yes.
Okay.
Not one single number?
I'm going to order pre-trial with no monetary bond, no drugs or alcohol, and I'm also going to enter an order so you can access your phone to let people know to come get you or whatever you need. All right?
We're here. You got to check in there first thing.
Yes, thank you, Your Honor.
Thank you, Your Honor.
Michael Birchfield.
Present, Your Honor.
All right, Mr. Birchfield, you were picked up on a violation of felony probation, and that is a no bond, so I don't have authority to change that status. You're scheduled to go before your trial judge on May 9th at 8:30. You can address it then. Thank you. Have a
Thank
good
you.
day.
Thank you, Your Honor.
George West Brown.
Present, Your Honor.
Okay, Mr. Brown, you are charged with possession of, what's PVP?
Like Flocka.
Oh, synthetic drug. Okay, that's what I thought I had read in there. Okay, you've been charged with possession of PVP or synthetic drugs, and I've read the probable cause affidavit. I do find probable cause. State your position on bond.
There is a 2016 possession of weapon by a convicted felon and resisting without violence. That case is still pending. 2016 petty theft adjudication. 2016 driving while license suspended charge, which is currently pending. 2015 petty theft adjudication, and a 2015 grand theft auto adjudication. Given that all of these charges are within pretty much the past 2 years, the state would be asking for a $5,000 bond on count 1.
Mr. Dessler on the issue of bond.
Your Honor, Mr. Brown lives in Fort Lauderdale. He's lived in Fort Lauderdale his entire life. He's 55 years old. He lives with his mother currently. He cares for her. He himself is actually on disability. He gets $645 a month from disability. He's unable to work because of his disability. You don't need to shout, okay? He's unable to afford any monetary bond. I would ask for him to be released on non-monetary conditions. He does have an address that he can provide to pre-trial.
Okay, I'm going to order pre-trial, no monetary bond, and no drugs or alcohol while you're on pre-trial. Have a good day. What is that?
Thank you, Your Honor. So we're here. You got to check in tomorrow.
That's a chair? I keep thinking there's like some kind of baby walking or something. I'm sorry. I can't hear what they say, but I can hear. Don't ask. Don't even. Okay. Kyle, it's just a weird little sound coming from over there.
No, out.
Kyle Joden Sanders.
Present, Your Honor.
Sorry, we were having squeaky chair issues over here. All right, Mr. Sanders, you were picked up on a violation of, is that community control?
Yes, community control.
Okay, felony. So that is a no bond issue, and I have no authority to change that, sir. You have a status scheduled on May 9th at 8:30 before your trial judge. You can take that up with them then. Thank you.
Thank you, Your Honor.
Roberto Hernandez.
North Broward. North Broward, Your Honor.
Thank you. Is that a medical reset, North Broward?
Sorry.
Hello. Let the empty chairs stand up. All right, we're gonna put Mr. Hernandez on recall. Let us know when he is present for us to chat.
These are medical. Something kind of resets.
That's on recall.
Yeah, just for the record, yeah, North Broward called me this morning, said that that was.
Oh, they called, okay, so it's medical reset.
Yeah.
If they called him, he's reset
All right.
tomorrow.
Oh, okay, fine. Kevin Christopher Daly.
Present, Your Honor. He's declined the services of the public defender. He says he's going to hire a private attorney.
That is your choice, sir. You have been charged with burglary of a dwelling or structure, armed burglary of a dwelling, structure, or conveyance, and also criminal mischief over $200 and under $1,000. I have reviewed the probable cause affidavit, and I do find probable cause, sir. State.
Yes, Judge, I don't have that he has any prior criminal history. Considering the first charge is a first-degree felony, the state would be asking for a $7,500 bond on that case and no contact with the co-defendant.
Okay. Sir, how long have you been living in Broward County?
I live in West Palm Beach.
You live in, so you don't live in Broward County at all? You don't have a
I
residence?
lived in West Palm Beach for 28 years.
Okay, so you don't have any residence in Broward County?
No, ma'am.
All right, and are you working?
Yes, ma'am.
All right. What do you do?
I install shutters and impact windows.
All righty. He doesn't have any priors though, Madison?
Nothing that we could find in the state of Florida. We can't do a national criminal history.
I hear you. All right, I am going to order. I'm gonna order a. How much do you make?
$18 an hour.
All right, I'm gonna order a $2,500 bond on count 1, and no monetary bond on count 2. And is your telephone in custody?
No, ma'am.
Right.
I do know numbers. I can call somebody. I know numbers.
Okay, all right. Then that's the order. The $2,500 bond on count 1 and no monetary bond on count 2.
No contact with the co-defendant?
And no contact with the co-defendant, sir. All right, that means that you do not speak to the other party that was arrested with you.
Yes, ma'am.
All right? All right.
Yes, ma'am.
Thank you. Justin Paul Pichet?
Present, Your Honor.
All right. Mr. Pete, is it Piche or Pichet?
Pichet, you're right.
Pichet. All right, you're charged with possession of cocaine and possession of cannabis less than 20 grams. I've read the probable cause affidavit. I do find probable cause. State, what's your position on bond and priors?
I have no priors, Judge. The state would be comfortable with the $1,000 bond that's already been assigned to count 1.
Mr. Dessler.
Your Honor, Mr. Piche, he's 63 years old. He has an address in Broward County. His phone and his wallet are in his car, so they're not at the jail. He has no way of contacting anybody to post a monetary bond for him. Given the fact he has no record, given the fact he's 63, I'm asking for him to be released on non-monetary conditions. If needed, he can provide an address pretrial.
Okay. All right. I'm ordering pre-trial with no monetary bond.
We were unable to verify his information.
Oh, all right, Mr. Dessler.
Yes, Your Honor.
pretrial wasn't able to verify that address. Do you think you're going to be able to?
One moment, Your Honor, let me just see.
He tells me he's lived there for 5 years. That
Anybody there to answer the phone?
No, my daughter's up in New York right now.
So there's nobody there to answer the phone?
No.
Yeah, see, no, okay. Pretrial, what do you do with that? Okay. What?
We're able to verify. He didn't leave any contacts. He had no contacts to verify the information.
His daughter's out of state. His daughter's out of state.
He doesn't know any phone numbers, Your Honor.
Oh, and he doesn't have his phone, he doesn't even have access to his phone. I think they said that he doesn't have it on at the jail with him, didn't he? Mr. Dessler, is it my understanding he
Yes, Your
doesn't
Honor.
have, he doesn't, the phone, he didn't have his phone with him when they took him into custody?
No, he says it's in his vehicle, not in custody.
Okay. Can you verify if you got his, does he even know his daughter's telephone number?
It's all basically on my phone.
Okay.
I don't remember things too well.
Pretrial, please help me out with this. We need to get a resolution.
What possibly he can do is do a pending verification and send the field team out to see if they get.
So they can release him and then send them, what?
He won't be released until we're able to verify that he lives there.
But if there's nobody to answer the door, he says there's nobody there, so how are you gonna verify?
We won't be able to verify.
You're getting me in a circular argument here.
Okay, sometimes if someone is living there besides his daughter, is that the only
There
person?
isn't, his daughter's out of state, he just said that, so give me a scenario that we can resolve this.
There, I mean, as far as pretrial. there's no
Okay,
way of
fine,
verifying
okay,
this
yeah,
information.
then fine, here's what I'm going to do. I'm gonna ROR him without
thank you.
pretrial. And, I'm just relying on Mr. Pichet to show up when he needs to show up and be at the address that we have that gets the notices. You can explain, Mr. Deschler, my faith
Yeah,
in
sure.
Mr. Pichet.
Yes.
Thank
Very much.
I almost read Bond here. James Bodie. I almost went. Look at how it quickly. Yeah.
Bonded, Your Honor.
Oh. Lindell Randall Green.
Present, Your Honor.
All right. Mr. Green. You've been charged with robbery, no firearm or weapon. I've read the PC. I find probable cause. Ms. Gomez?
No priors, Judge. The state would be requesting the standard convenience bond of $3,500 on a second-degree felony.
Mr. Dessler, on the issue of bond.
Your Honor, Mr. Green lives in Hollywood. He's lived there for 1.5 years. He lives with his mother and his stepdad. Unfortunately, Mr. Green is unemployed. He collects SSI and disability. He's disabled, which is why he's been unable to work. He's been collecting it for 1.5 years. I'm asking for the bond to be set at $2,000.
All right, I'm ordering a bond of $2,000 and no contact with the victim.
Thank you, Judge.
Thank you.
Christopher Daniel Knowles.
Present, Your Honor.
Mr. Knowles, you've been charged with grand theft, over 500, under 5,000, and a violation of community control under your felony.
Your Honor, he's currently out on pretrial for two different case numbers. The first case number is 1600720 CF10A for grand theft, third degree battery. And we're requesting that his pretrial is revoked. And also case number 130067627 CF10A for aggravated battery with a deadly weapon involving the scene of an accident. And we're requesting this pretrial is revoked on that case number also.
Okay, well, pretrial's revoked. You can address those with your trial judge as to any subsequent on those other cases.
And I have one more case number, I'm sorry, Your Honor, I didn't see this one.
Another pretrial?
Case number 1601377 CF10A for grand theft. He's currently on pretrial for that one also.
All right. As to, do you have anything else I need to? Did I sign the wrong place?
Are you gonna do no bonds with the bond amounts on the cases?
Okay,
on
when
pretrial?
I,
For the cases that he's out on pretrial for.
other cases, they're not,
He has 2 pending grand theft cases from 2016.
but they're not before me to set bond.
They're not before you to set bond. They could be before you to revoke their pretrial release, if that's what Your Honor chooses to do. Basically, he's out on pretrial and committing new crimes, so pretrial's asking you to revoke his pretrial release because he's pending these crimes and he picked up something new.
Your Honor.
Oh, that's exactly, then perfect. It's not a bond.
She's asking you to either put no bond or set a bond when you revoke the pretrial.
Oh, okay. Mr. Dessler wants to chat with me about that. I'm sure.
No, I was just gonna say, Your
I
Honor,
can tell he's chomping at the bit to chat with me about that. Right, Mr.
So he has a
Dessler?
violation of community control.
Right,
He's
there's
being
no
held no
bond there,
bond.
so
It doesn't. Nothing needs to be
it's
revoked.
kind
He's
of a
going to
moot
stay in
point.
custody. Yeah.
I hear you.
We still have to
You still have to revoke. Well, then, basically, I'm not setting a bond on those. I'm gonna let the trial judge address all of those issues, because that's probably what the violation of,
Okay, so you denying the
No, she just
revoking
said she's
the
not setting a
case.
bond.
I'm not setting a bond on those. I'm
No bond.
No, holding no bond.
holding no,
It's okay, we know what you mean.
get the translation from them. They know exactly what I meant. All right, as to grand theft. I mean, setting a bond is like a moot point.
It is, Judge. I mean, the convenience bond right now is set at $1,000. If Your Honor has revoked his pretrial release on the 2016 pending cases, and then he's got the violation of community control being held no bond as well.
Right. Mr. Dessel, what's your position on count one?
I have no objection to the convenience bond, Your Honor.
Fine, we'll do the $1,000 bond for count one, and he's still on the no bond hold for the violation. I'm not setting any bond on.
He'll see his judge on
He'll
Tuesday
see his
night.
judge on Tuesday. What time? Oh yeah,
Tuesday night at 8:30.
I think didn't I tell him that already?
I don't know, but
May 9th, 8:30. He's already got his hearing.
Thank you, Your Honor.
People make me do I have to? No. Johnny Reese.
Present, Your Honor.
Okay, Mr. Reese, you're charged with destroying, damaging, altering electronic monitoring equipment.
Your Honor, he's also currently out on pretrial. Case number 1600364 CF10A for grand theft, third degree. We're requesting his pretrial is revoked.
He destroyed your equipment. But the allegation is he's destroyed your equipment. All right, I do find probable cause. Stay.
The state would be requesting a $5,000 bond, and if he was to be released, well, no, if he bonds. With some sort of monitoring system, Judge, if he does bond out. I understand the allegations in here, but I don't want him to just get a bond and then not have any sort of follow-up with that.
Mr. Dessler, your position on that?
No objection to the $5,000 bond or the electronic monitor, Your Honor.
All right. Like that favor. All right, I'm going to order the $5,000 bond and electronic monitoring.
That's on the new case.
Well,
my concern is that if we give him a $5,000 bond, he pays the convenience bond, there's nothing to follow up with it afterwards. He's entitled to some sort of bond. We can't just hold him no bond. So I'm trying to give a bond with some protection.
Hang on. I know where you're going, and I may amend that, okay? You keep getting me down that path of I say something and then no. So the pretrial that he's on with the monitoring is what you're asking me to revoke.
You signed it at
You
no
give me
bond,
that order.
which is gonna hold him in custody.
I didn't even say anything about bond. You were asking me to revoke. We hadn't even gotten there yet. You jumped the gun on that with me every time. All right, so, but the state's issue, I mean,
That's fine.
okay, you're gonna remain under the charges that you currently have pending under pretrial with a monitoring device and now the $5,000 bond.
Thank you, Your Honor.
Jose Manuel Jimenez.
Yes, ma'am.
Okay, you're charged with aggravated assault on an officer. Firefighter or EMT, touch or strike battery, and disorderly conduct, breach of the peace. Mr. Hawker, you are standing. You would like to address probable cause.
Something you heard is the count one aggravated assault. I don't see anything in the probable cause affidavit that stated that there was an aggravated assault on the police officer. There was no weapon used. The only thing I could see that would rise to an assault was he clenched his fist, turned this officer, threatened to punch him in the face, but there's nothing in the probable cause affidavit that would state that there was an aggravated assault on the police officer. We would ask the court to not find probable cause on count one aggravated assault on all law enforcement officers.
May I have one moment, Judge?
Yes.
What's the statute?
784.07. So Flostat.
What's the subsection?
2C. Yeah.
They were nice to me yesterday. We're waiting on the state's position on the contest of count one probable cause. State, I may make it easier for you.
Okay, Judge.
Based on my reading of the probable cause affidavit, I am willing to find probable cause for a lesser resisting with violence, but not aggravated assault on an officer.
That's fine, Judge. So you'll be finding probable cause on resisting with violence, a third-degree felony.
Based on,
the allegations in the report.
yeah, I think the aggravated assault's the third as well, correct?
Say that again, I'm sorry?
The aggravated assault is a third as well.
No, that's a second degree.
The law enforcement officer would be second.
Second, higher level. Yeah, but I don't see the aggravated aspect of it, but I do see that the probable cause affidavit clearly states that he was notified that he was under arrest for battery and disorderly conduct, and that's when he used very inappropriate word, threatened to hit the officer, and then turned to the officer with clenched fists. So that to me is resisting with violence.
I understand, Judge.
Did that satisfy your objection to count 1 PC?
Yes, sir.
All right. I am finding probable cause for count 2 and count 3. State as to bonds and priors.
I don't have any priors, Judge. The state would be asking for a $5,000 bond on count 1, the standard $1,000 bond on count 2.
Mr. Dessler, your position
Your Honor,
on bond.
Mr. Jimenez lives in Fort Lauderdale. He's lived here for 2 years. Both his girlfriend and his brother live in Broward County as well. He has a job as a Krispy Kreme delivery driver. He's done that for 1.5 years. Currently, he's on medical leave. He had spinal surgery. He was in an accident, so he's been out of work. He's been collecting unemployment.
Yes.
He's going to be going back to work in the near future. I would ask for count 1 to be set at $2,000 and count 2 to be set at $1,000 for Mr. Jimenez.
All right. I am going to order $2,000 bond on count 1, $1,000 bond on count 2, and pretrial release. Can you verify? Have you been able to verify? It sounds like there's somebody there.
Your Honor, we just ran his own criminal history.
All right. Do you have an address, Mr. Dessler, that you can get so that pretrial can
Do you have an
verify
address?
the address?
What?
Yes, Your Honor.
And if there's somebody there that can answer that he lives there? Somebody
Yes,
there
ma'am.
to answer the phone that they can verify?
Yes, ma'am. She just got a number change, so I don't know it, but she has my phone. You can probably call my phone and she will answer it.
Okay, Mr. Dessler, somehow get that number to
Yeah.
Mr.
You're good, Tom.
Hawker. And
My
then
license.
Mr. Hawker. Yeah, all right?
We're good, Joe. Thank you.
All right. Will that pretrial satisfy what your needs are? He's on pretrial. I'm Dwayne Jeremiah Castiglione.
Present, Your Honor.
I'm sorry, on the last case, are you ordering no lethal contact?
Oh.
The aggravated assault.
Yeah, I assume he's not contacting the officer to have any, but yeah. The prior one is no, Mr. Dessler, just let him know, no contact with the victim, the law enforcement officer.
Mr. Jimenez, no contact with the victim. You understand?
I think there's a
He understands,
civilian
Your Honor.
victim in the case
Oh,
as
there's
well.
also a civilian victim, yeah, no contact with the victims.
No contact with any of the victims. He understands.
That's how the officer originally showed up there. Gotcha. All right, Mr. Castiglione, you are charged with possession of burglary tools with intent to use and trespass occupied structure or conveyance. Mr. Hawker, you have an issue with probable cause.
Yes, Your Honor, it relates to count 1. States possession of burglary tools with intent to use. The allegations on the probable cause affidavit that he locked himself in a bathroom, entering into an arrest. There were were tools found on him, but there's a lack in the probable cause affidavit stating that there was an intent to use. There was no mention of he intended to use it while he was on the property. It would just simply be the possession, Your Honor. We would ask this court not find probable cause on possession of burglary tools with intent to use.
State.
He had locked himself in the bathroom at the time, was refusing to leave. The item that was found on him was a spatula that had been molded to be a prying and cutting tool. There is nothing in the report as to what they expected him to do inside the bathroom with that tool. He was already inside at that point. I don't know if he was intending to damage any of the things inside the bathroom.
Did he use that to get into the house?
It's not a house, it's a restaurant. I'll defer to Your Honor. I understand what's in the probable cause.
All right. I am finding no probable cause on count 1 based on the affidavit, but do find probable cause for count 2.
May we have 48 hours to perfect count 1?
Yes. Any issues as to bond?
I have a 2017 withhold on a trespass, 2006 battery withhold, and a 2005 burglary of a dwelling adjudication. I would be asking for a $500 bond on count 2, the trespass from the prior criminal history of trespass and burglary of a dwelling.
Mr. Dessler, on the issue of bond.
Your Honor, to be blunt, Mr. Castiglione, he's homeless. He can't afford any monetary bond. I would ask for him to be released on non-monetary conditions. Otherwise, he's just going to be held here on count 2 on the trespass.
How's he gonna know when to show up? Do we have any address to send notice?
He knows the number to call the clerk to ask about his court dates. He's telling me that.
Okay, so you'll just call in to find out your court dates, Mr. You gotta go.
I've never missed a date.
Oh, all right.
Deputy, he needs a pre-trial date.
All right. I'm sorry, background here. All right, I'm ordering ROR, and pending perfection, we'll see what the state comes up with, and they'll address that issue then.
Thank you, Your Honor.
I ordered ROR on count 2, state's perfecting on count 1, so I'm not ordering any monetary on that one. Count 1, they're perfecting.
Do we need to leave this?
They have 48 hours to perfect.
So we're gonna leave the 1,000, or we're gonna RR?
No, I didn't put the 1,000, no, we're not leaving the 1,000. Okay. There's no monetary on count 1. States has 48 hours to perfect, and I'm doing an ROR on count 2. Derek Charles Horn.
Present, Your Honor.
All right. Mr. Horn, you're charged with burglary of an unoccupied conveyance, unarmed, and petty theft, first degree, property over 100 but less than 300. Mr. Hawker, you have an issue with probable cause.
Yes, sir. This relates to count 2 of the allegations. You know, based on the probable cause affidavit, what was taken was $4.45 and change, and a black Spider-Man hat, which no value was given. And we believe that the probable cause is insufficient to charge Mr. Horn with petty theft of property from greater $100 to less than $300. We don't believe that the value of $100 has been met. And the probable cause is silence the actual value of the black Spider-Man hat, but unless it's over $95, it wouldn't meet the threshold.
State.
Yes, Judge. Even if it's a second-degree misdemeanor, if it's the person's, I believe, second or subsequent conviction, the state can charge it under the first-degree misdemeanor. It may have been, the statute may have been put in correctly, but he does have 2 prior petty theft adjudications from 2010. So we're trying to find the actual subsection it would be under.
So is it just incorrectly subsection?
It looks like that would be the
So you
case.
just need 24 hours to perfect the subsection?
I mean, if Your Honor's willing to find probable cause on a petty theft second degree, which would be or technically, I guess, $1 to $100, which there is allegations of
There are
$4.45.
sufficient allegations to meet the second degree. So I will find probable cause as to second degree petty theft of $1 to less than 100.
Yes.
And I find probable cause as to count 1. Now, state.
2, 3.
Do you have priors and any recommendation as to bond?
Yes, Judge. There's a 2014 possession of heroin adjudication, 2014 tampering with evidence and possession of oxycodone adjudications, 2012 resisting without violence and possession of drug paraphernalia adjudications, 2012 possession of oxycodone withhold, and as I mentioned previously, 2 2010 petty thefts that were adjudications. The state would be requesting a $5,000 bond on count 1 with no victim contact.
Mr. Dessler, as to bond.
Quite like the last client, Your Honor, to be blunt, Mr. Horn is homeless. He has no address. He does not stay in any shelters. He's unable to make any monetary bond. I would ask for him to be released on non-monetary conditions, and he can call the clerk to find out what his date is.
All right, I'm going to ROR on count 1 and no monetary bond on count, and ROR on count 2, and no contact with the victim. And that means not going near the residence either. That means no contact. Just call in to get your court dates, okay?
Thank you, Your Honor.
All right. Cody Jackson DeMatte.
Present, Your Honor.
All right. Mr. Mattei, you were picked up on violations of probation for 2 felony probations under case number 15-1. Is that 150 or 160?
1601.
1601 and 14-17024. You have those are no bond because of the violation. You have a status on those on May 9th at 8:30. You'll talk to your trial judge about those. I have no authority to change it.
Thank you, Your Honor.
Have a good day. Santiago Rebello.
Bonded, Your Honor.
All the way to that first clip.
Okay. Anthony Trendrail Daniels.
Present, Your Honor.
Okay, Mr. Daniels, you've been charged with possession of a weapon or ammo by a convicted felon. Possession of a weapon or ammo by a convicted felon, that's 2 counts. Discharge of a firearm in public and resisting officer obstruction without violence. Mr. Hawker, you have an issue with probable cause.
Yes, Judge. As it relates to count 1 and 2, possession of a weapon, I have really a problem with all counts, but I'll go in turn. As far as count 1 and count 2, there was the probable cause affidavit states that the officer heard a gunshot and then coming from an open field, and then saw Mr. Daniels running. There was never anything in the probable cause affidavit stating that he saw Mr. Daniels in possession of any firearm or ammo. There's nothing in the probable cause affidavit stating that Mr. Daniels admitted to possessing any firearm. It's just as plausible that Mr. Daniels could have been running because he heard the gunshot as well, but was running for his own personal safety. So there's no evidence of possession as it relates to count 1 and 2. As it relates to count 3, again, I mean, the only thing that could be construed as resisting an officer without obstruction without violence is Mr. Daniels running. There's nowhere in the probable cause affidavit that says that the cops were trying to stop him, that he was ordered to stop, or that he was running from the police. He was simply running after hearing a gunshot, Your Honor. I think that that's a plausible reaction of hearing a gunshot, especially if you're not the person who shot the gun. As far as to count the count of discharge of firearm in public, again, Your Honor, the officer states that he just heard a gunshot. There was no evidence provided that Mr. Daniels was the person who discharged the firearm. Again, you hear a gunshot, you see Mr. Daniels running. There's no evidence of discharge, there's no evidence of possession, there's no evidence of running from the police, Your Honor. We would ask this court not find probable cause on any of these charges.
State would request 48 hours to perfect.
On all counts?
Yes, Judge.
Okay, well, I concur with the public defender in their assessment of reading this PC. I do not find probable cause on any count. I will give the state 48 hours to perfect at this. Mr. Dessler, you wanted to say something else before
I just want to make sure, so he's going to be released on his own recognizance since you're not finding PC on any count.
Judge, I believe there's a Florida Rule of Criminal Procedure that states that probable cause needs to be found before you can ROR.
Right, so.
No, before he's ROR'd.
Yes.
We have the 48 hours to perfect.
Oh, you want.
Can I have a moment to look at the rule so that I can cite it for Your Honor?
Well, both of you are gonna go checking the rule because she's checking to see that I can't ROR them while they are perfecting. Somebody get me the rule to show me one way or another. If that's the case, I may shorten the time frame.
I believe we have 48 hours pursuant to the rule as well, Judge, so I don't know if that's something that can be shortened.
All righty then. While you're looking at that, can we just call the next case while you're looking that up? Can I handle?
Sure, I believe
Just put him on recall, I'm not done yet.
We can put him on recall, Your Honor.
Okay, no, just so I have not finished with this yet. Wendy Preville?
He's present, Your Honor. His attorney's Michael Cohen.
Does his attorney know he's here today or present?
Yes. Yes, I talked to him.
Oh, this is the reset from yesterday?
Yeah. It was the reason from yesterday. Yesterday he hadn't talked.
I thought you were busy.
Did anybody call Mr. Cohen?
I talked to him.
Oh, you called? Did he say he was coming today?
He told me to find out my court date and contact him immediately.
Okay, so he wants you to just handle this, and then you'll let him know and he'll show up for the real judge.
Yes. Yes.
Okay. Okay, Mr. Preville, you are charged with driving with suspended, revoked license and expired tags less than 6 months. And there's also a violation of probation on your felony case. And the violation of probation is a no bond. I have no authority to change that. So you are set to go before the trial judge on May 9th at 9 a.m. So you can let your attorney know about that. As to the other, I do find probable cause for the other counts, but I'm going to let the trial judge deal with the issue of any bond on those counts, since you're no bond on the violation, and you'll be before the trial judge on May 9th to address all of the issues. State, do you have any other position?
No, Judge, that's fine.
All right. What?
Your Honor, who's my judge?
Who is The same judge you had before that when you were put on probation. That judge.
I had two different judges.
All right. Okay, well, well, hold on. There was who signed the, well, I don't know. What division is it? Oh, it's FA,
No, it would be Judge Lynch.
Judge Lynch is
took
your
over.
judge.
He took over Judge Porter's division.
Yes. All right.
You tell your attorney. May 9th.
Yeah, call your attorney, let him know. May 9th.
Good luck, everyone. Put it in your pocket and I'll put it.
Okay, Casey
They can call
Meyer.
tomorrow.
He's present, Your Honor. His attorney is Michael Weinstein.
This was the recall from yesterday. Where's Mr. Weinstein? Hi. Did you let
Hi,
Mr.
it's the recall.
Weinstein know? Mr. Weinstein wasn't here.
Casey, it's this one.
Yeah, I don't think my buddy tried to get a hold of him, and I don't think they're open on Saturday and Sundays. So that's why I haven't got a hold of him yet.
Interesting. Most of them are cell numbers. Everybody can get a hold of them, but all right. I mean, they're.
I'm supposed to have a court date coming up on tomorrow, which is the 8th.
I don't have anything on mine. Does he have a court date?
He has a pending 2016 case, Judge. We were going to move to revoke his bond on that case.
Oh.
These are the same victims. The other case is, if I'm not mistaken, an
Well,
aggravated
then-
battery.
Well, here's the situation, sir. You're on the.
No.
So he was picked up on the Capias arrest? Is that what we're hearing? So I'm looking at the Hollywood Police Department Capias arrest. So
Yes, he's
here's-
being
that's,
held
That's what we're here. That's what he's before me on.
No bond on the aggravated assault, yes.
That's why he's here.
That's why he's here today, yes.
Okay. All right then. Well, Mr. Meyer, I mean, your attorney had the opportunity to come, but the situation is still the same. You were picked up on the warrant, the Capias warrant, on your prior aggravated assault charge. So that is a no bond right now event. That warrant says your trial judge put no bond. They want to see you live and in person to determine anything further. So I have no authority to change that. So you'll be held until you go before your trial judge at whatever hearing you know you have. I don't have a date for it, but whenever that is, that's when you'll go before that trial judge and address it, okay?
Yeah, because it's supposed to be on the 8th, but you don't know.
Well, I don't have it on mine. You may have information that we don't have. Okay, somehow, okay, but that's the status right now, sir. You seem to know more than we do, and you'll go before the trial judge, all right? Have a good day.
Okay, ma'am.
Luchin Moreau.
No brow, John.
Who's none? There's no one who was just there. What? Meyer, no, it says on the warrant, no bond.
It says hold for magistrate, but the bond itself is I believe it's a not in custody capias that says no bond amount. It says total no bond hold on the capias itself.
Yes.
Okay. It's not your
I'm keeping it right now. I mean, essentially, his attorney had 2 days to show up and try and tell me that this should be different. He says he's gonna see him on the 8th, so it's not like a while away. Did we have, where'd Mr.
No
Lutz-
brow, no brow, John.
Thank you,
No brow.
sorry.
That's okay.
There's a lot of discussion over here about collateral stuff. Hi. All right.
How you doing, Lauren?
Yeah, all right. Mr. Moreau, you are charged with trespassing of an occupied structure or conveyance. What, corrupt by public.
I don't have any of this paperwork, Judge. I don't
You wanna look
know
at
what
what
we're
I have?
addressing.
Reset from yesterday.
We had a stack of them.
Oh,
I
is this
don't
the
see them
medical
there.
one?
Yeah, let's see.
There was
What I write
something
on the
he-
bottom, because I did
You
write the
did
little
write
little
in,
notes.
okay, not on this one.
Right here.
But I remember there was something that
Yeah,
he wasn't
that was the
available.
medical.
Yeah, he was unavailable, he was reset for, because of medical, yeah. All right, so, you're charged with corruption by threat of public servant or family, and corruption by threat of public servant or family, count 2, and count 3 is trespassing, occupied structure or conveyance.
Huh? I don't have paperwork for it, no. Come up on Odyssey and see if maybe.
Your Honor, can I say something right quick?
Mr. Harper, are you like,
Yes, Mr. Morel, I would ask that you not address the judge regarding the facts of your case. Everything that you say right now is being recorded. Anything can be used against you in further proceedings, okay? I
Yes, sir.
talked about you earlier, so I'm gonna make my arguments on your behalf, but I ask that you not address the judge as it relates to your charges, okay?
you understand, Mr. Harker? You were present
ma'am.
this morning to hear my colloquy about you have the right to remain silent?
Yes, ma'am.
And the public defender, as your attorney right now, is trying to tell you to reinforce that, okay? All right,
Yes,
Mr. Harker, you're standing, is it just to talk to him or to talk to me?
Yes, to address Mr. Morel.
Okay,
To
but-
invoke his right to remain silent.
Okay, all right. But you didn't have anything else to say about what I'm about to say about PC? I'm just asking, sometimes you're,
Not about PC.
all right, thank you, all right. Well, I reviewed the PC, I am finding, probable cause state, on the issue of bond.
Judge, I have no booking reports from this gentleman whatsoever.
It
So
was from yesterday.
all of the medical resets I thought were in a separate stack, and his paperwork is missing
Did
completely.
you want to take a look at this?
Possible, yes, please, thank you. Do you have his date of birth?
I have his.
Do you need it?
No, it's his name is interesting.
Judge, as to priors, we have a 2017 resisting or obstructing without violence adjudicated guilty, trespass adjudication withheld, a 2017 violation of injunction against domestic violence, he was adjudicated guilty on, trespass 2017 adjudicated guilty, 2017 disorderly conduct and trespass after warning adjudicated guilty, 2016 trespass adjudicated guilty, 2016 trespass adjudication withheld, 2016 trespass adjudication withheld, 2016 burglary of a conveyance unoccupied, which was adjudicated guilty, 2016 trespass adjudication withheld, 2016 trespass adjudication adjudicated guilty, I apologize, 2015 trespass adjudicated guilty, 2015 trespass adjudication withheld, 2015 violation of an injunction against domestic violence adjudicated guilty, 2015 disorderly intoxication adjudicated guilty. 2013 trespass of a structure adjudicated guilty, 2013 driving charge adjudicated guilty, 2012 possession of cannabis adjudicated guilty, 2010 bribery of a public servant and operating without a valid driver's license adjudicated guilty. Does Your Honor want me to keep going?
Not real.
Okay. It continues from there, though.
Okay, so your position on bond.
State would be requesting a $10,000 bond on each count.
Your Honor, Mr. Moreo is a lifelong resident of Broward County. He does live with his mom in Sunrise, Florida. He doesn't have any money, but he did just start working in landscaping a week ago. He will be working with his stepfather, who he also lives with. And also, he's obviously dealt with several medical issues given the medical resets. And
Does he have a viable address that pretrial can verify? Pretrial, hello?
Yes, Your Honor.
Hi, this is almost last but not least, so I'm not gonna call on you too much more today.
Your Honor, he would need to be, if you can inquire with him if he has a viable address.
Oh, Mr. Moreau,
Yes, ma'am.
where are you living right now? Well, not
At this moment,
but like before you got arrested.
I was staying with my mother, but I had a ejection order over there, so I had to move from over there. I was living in hotel to hotel when I was working, provide the bills there.
Okay, so.
But right now I'm getting the restraining order resolved. That's why I couldn't be there. So.
Okay, but you haven't gotten the injunction resolved yet.
No, ma'am.
All right, so right now you're living from hotel to hotel?
Yes, ma'am.
Yeah. There goes the problem. We can't verify an address because he doesn't have one. Huh.
I mean, only there's only way you could release me on R&R. I show up in court and everything. And I have kids to support too. You know. Please.
Hang on. Okay, state. I heard, but a lot of that's all trespass stuff.
It is.
You know, I mean.
There are some felonies that are included as well.
Old.
None of those were old. I only got till 2009, and then we kept going from there. That was all 2009 and till today. Several of those cases were just this year, even though we're only in May.
Trespass ones or the?
Violations of domestic injunctions, the trespass. I don't have it up here again,
Right, which
but
appears to be all in that realm of.
burglary.
Pardon me?
There was a burglary that was involved.
2016 burglary of a conveyance, adjudicated guilty.
Is there, other than your mom, is there anybody else you can stay with?
Not necessarily. Not right now. Not at this moment.
And he doesn't have a court date pending, does he?
All of the cases were closed out.
And what is your what are you asking for?
In light of the fact that he doesn't have anywhere to stay, and the fact that he admitted that he would come to court, I don't know if he has any cases history, but.
And I just started school too.
He just started school as well. Now, given the fact that all his cases are resolved, that would lead me to think that there probably weren't issues with cases, given he had to be present to resolve them. We would ask this court for a non-monetary bond.
Okay. Ms. Gomez, I didn't hear anything about capiases in that roster.
I would have to pull up each individual case to look at capias history.
Well, here's the thing. Given the situation and the fact that there is nothing said immediately and the nature of the charges, I'm going to ROR at this point in time. Mr. Moreau, don't let my faith in you down. I'm releasing you
I got
in
you.
ROR. You get to work, you get to school, you support your kids, and you show up in court.
God bless you.
Have a good day,
All counts,
sir.
right?
What? Okay, are we?
Mr. Daniels, Your Honor.
Yeah.
That you found no PC, and the state wants to hold him for 48 hours, even though you found no PC on any of the counts.
Yeah, and they say there's a law that says I can't ROR him.
Which doesn't make sense to me, Your Honor, because then it would be better off for you to find PC on one of the counts to release him, or for him to be able to postpone, rather than you not finding PC and for him to be held for 48 hours.
What
no
a
bond.
conundrum, huh? They're looking for the law, because I'm big on, if it exists, show it to me.
And I understand. I found what the public defender was saying. There's Florida Rule of Criminal Procedure 3.133. I don't know the title of it. If we
Did
scroll,
he find it?
It-
Does it help you, Mr. Dessler?
it helps Mr.
Actually-
Dessler. Yes.
Mr. Dessler, why don't you read what you found that the state is
No, I don't have
acknowledging
it.
helps you?
I don't have access to
found it
anything
for
over
him,
here.
Judge.
Oh, the state found it for you. See, I like when everybody works together for justice. So, what does it say?
It states that if the judge does not find probable cause to believe that an offense has been committed, the judge shall release the defendant from custody unless an information or indictment has been filed, in which event the defendant shall be released on recognizance subject to the condition that he or she appear to all court proceedings or shall be released under a summons to appear before the appropriate court at a time certain.
Ah.
Such
Well-
release does not, however,
So,
void
if they
further
find it.
prosecution by information or
Right.
indictment.
Okay. Well, it's interesting what I hear is because I have two options, and that is to just release or to or if there was another one, if I found that there was reason to believe that a crime had been committed.
Well, no.
That's why I like to see something in my hands and stuff.
Well, Your Honor had already found there was no probable cause. So
Exactly.
that's the first portion.
yes.
If from the evidence it appears to the judge that there is probable cause to believe an offense has been committed and the defendant has committed it, the judge shall cause the defendant to be held to answer to the circuit court.
Oh,
However, and then that was the portion that I read. So
that
you-
I can release him.
from my understanding of the rule, you are correct.
Make it so.
Your Honor, I'm asking you to release Mr. Daniels, and if the state files information.
I said yes.
Thank you.
So
Thank you.
He's released, and they've got to perfect.
Bless.
They've got 48 hours.
Appreciate
Mr. Dessler,
Have a blessed
he
life.
can
Yes, sir.
do short sell, but they still have 48 hours to perfect.
Such release does not, however, void further prosecution by information or indictment.
Just so he knows. They have
Oh,
48
right. No.
hours to
He knows
perfect.
this. Right, but he doesn't need to appear for that. So
No,
it'll
he
be.
does not.
Right. No, I know. I'm explaining for him. That'll be with the attorneys, and this doesn't end his case, but he's going to get released
You're
today.
getting released today if they process right away.
Yeah.
So make sure
All
your
right.
app is right, because if something happens, they're gonna mail it to your app, so when you get released, look at your app if they're correct. It's not
All right. You have a blessed day.
You too. Okay, I think that concludes.
That's everyone in Maine.
That's all I have.
That's everyone and everywhere else. I don't have any more paper in front of me. Bye. Have a good day.
Thank you. You too.
The paper clip.
We should be shut off.